Hi, and welcome to the AdaKay Show. I am AdaKay Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning, everybody. Today is going to be a little interesting. We are in the charge, as they're calling it, the charge conference. Or in other words, we're going to watch them fight over the jury instructions. Thank you, everybody, so much for joining me today. Sorry about the long intro. My coffee was loud while it was brewing. I want to thank first in chat, Aaron, Tinkitude, and June, 80s Music Man, Jesse, Janet, welcome. You're the best. No, y'all are the best. Christy, thank you so much. Honey and K Swan, y'all are awesome. And if y'all haven't already, go and get yourself some merch. We have in my humble opinion mug. We have another mug that's what? So y'all go look over there. Like I said, I'm sorry it took me a little longer. My coffee was brewing. I need my coffee this morning. I woke up and I had no headache this morning. Woohoo! All is good in the neighborhood. Something I would like to do today. And let me get my thing connected. It didn't connect. One thing I would like to do today is, if we have some time, not too sure if we do, but if we do, I would like to go back and watch the victim interviews after the Kohlberger sentencing had finished. They had hello, human being 34/7. Welcome. But anyway, I'd like to go back and watch those. I have them queued up and ready to go for us. I want to thank everybody so much for being here. It has been a wonderful week with you guys, and I cannot believe tomorrow is Friday. And guess what happens on Friday? Guess what Friday is? Oh, Mandy, your pet pics. By the way, in Discord, we have a place where you can put your pet pictures. Tomorrow is going to be Lori Daybell sentencing. I'm all excited. I'm excited for the families. I'm excited for the oh my gosh, why is my brain not functioning? My brain is malfunctioning. Um I'm excited for the victim impact statements. Not to be excited for the wrong reason, but it's about time. You know, these people have waited a very long time to make these impact statements, and they're going to be able to do that. They're finally going to be able to speak. Brandon B. What's Brandon B? I better get my calendar up. And my fabulous son has blessed me. Hopefully, are you blessing me or are you eating it? No, don't eat my meal. He's eating my eggs.
Your Phil. The rest.
I will. He made me breakfast this morning. Let me see. On the schedule for tomorrow is Becky Hill also has a hearing tomorrow. We do not have Ali and Alibaba. We don't have them tomorrow, but we do have the hearing for perjury on Becky Hill and the Lori Daybell hearing. Hunter is so cute and funny today. Oh, that's good. Brandon Boudreaux. Does he have something coming up tomorrow? I don't have him on my schedule. Do we have something with Brandon Boudreaux tomorrow? If so, let me know. And he gets to get away with it since it's his birthday. Woohoo! Let's see what they're saying. When is Brandon Boudreaux's let me Google it. Lori's sentencing is yes. Oh, that's right. Hello, my bad. I'm not awake yet. My gosh, y'all! I got to tell you, I knew it was Brandon. I was like racking my head. I'm not awake yet, and I'm not that stupid. I slept so well last night, y'all. I ain't lying. I slept so well last night. My brain has not functioned all morning. Have you ever had one of those nights where you wake up and you just can't get your brain moving? Just can't get your brain engaged. My brain is still kind of engaged in the Alibaba over here. And the why we're calling it Alibaba is that means that's his last name is Ali and Baba is father. So we are kind of making fun of him. But that said, Donna Adelson, we're going to really start diving into her trial as well. We're going to start watching some things. I think next week we have some days where we don't have any. Good morning, Yana. I know the schedule's always good. Yeah, I know. My brain's not engaged. I've spent all morning typing a paper on human trafficking for college. That's a class that I'm taking right now, and it's on human trafficking, and I had to write a big paper on it, and my brain hasn't switched over. Woohoo! AC back on. Slept hard. You know what? My AC was too cold. This girl, I just burrowed under the blankets. Maybe that's why I slept good because it was the temperature cooler here in Kerrville, and I just slithered into those blankets. And I mean to tell you, it was so comfy. When you wake up in the morning and the bed feels like the best hospital bed? I mean, hospital. See what I mean? Hotel bed, and you just don't want to get out of your bed. It is so perfect. That was this morning. What, Penny? My paper?
30234.
Here we go.
241-132534 State versus Ali. This matter is before the
Ooh,
court
sorry.
today. The evidence has concluded in this case, and the court needs to address appropriate jury instructions. Ms. Stone and Ms. Zoe are present on behalf of the state. Mr. Kading is present with Mr. Ali, representing Mr. Ali, and Mr. Leary is present with Mrs. Ali and representing Mrs. Ali. Yesterday afternoon, after the conclusion of the evidence, I provided to the parties draft instructions and explained kind of how I put those together. I would just indicate, in case there's any questions, the copies I gave to the parties were double-sided. The original instructions will not be double-sided.
Matt, come
I
here.
do run instructions continuously, i.e. not a single instruction on each page, but I will never break up an instruction between two pages when the final instructions are put together.
Thank you.
You're good. I'm surprised.
As to, and as I refer to numbers, I am referring, of course, just to draft instructions, but I'm not going to repeat the word draft over and over again. So as to instructions 1 through 3, any issues with those? And I don't know if Ms. Stone or Ms. Zoe are going to be dealing with issues related to jury instructions.
I will. I'm sorry. May I remain seated while we have this conversation?
Of course.
Thank you. No issues. What's 1 through 3?
All right, Mr. Kading.
No issues, Your Honor.
Mr. Leary.
No exception.
All right. Number 4. The state and Mr. Kading submitted the same instruction.
Are you meaning like Colby Ryan, the Lori Daybell's son? That Colby Ryan? Is that who you're talking about? What?
Mr. Leary submitted an instruction that has bracketed information from the WIPIC, which includes what is often referred to as the abiding belief language, the last sentence. And I have that bolded in the instruction so that it would be clear that that was the issue that I would be addressing. Mr. Leary, I thought I would hear from you first.
As I'm sure everybody is well aware in terms of the arguments associated with WIPIC 4.01.
Yep.
It's not error to include that language. It is discretionary as defined by the comments and by the bracketed material in 4.01. I do object to language where the court is directing the jury as to whether they are satisfied beyond a reasonable doubt. I would also note that in the introductory instructions that the court provided to the jury when discussing reasonable doubt, the court did not include the abiding belief language, which I did note. Would ask to be consistent and simply I object. And I'm not aware of this court's policy, and I know that courts generally have a standard policy. So that's my argument.
Thank you. Mr. Kading, your instruction did not include that language.
Mine did. The abiding belief, I believe. It did not.
I don't think so, but I could have missed it, certainly.
They think it's viral meningitis that's causing it, but we'll play the video in a minute. Horrible.
I'm looking at your initial instruction, and you included the abiding, so you want the abiding belief.
I don't
Language.
object to it. I mean,
Okay, because that's what was in your proposed instruction. Yes, so that's, and I apologize if I wasn't clear. You did propose that language.
Right.
Yes, all right. And that's why I indicated on the draft instructions that it was only Mrs. Ollie's instruction that had that language. Ms. Stone?
Thank you, Your Honor. Your Honor, I think counsel is correct as to the law regarding the abiding belief language. That is discretionary for the court. Obviously, the state would note that that language is regularly given. It is appropriate to give that language. The state's position consistently has been, when we are talking about reasonable doubt, that is not a objective measurement that the jury can look at information and say it's this percentage. There's no numerical value. And while we talk about it regularly as attorneys, especially as criminal attorneys in the course of the law, that has become, I would argue, a very we have much more familiarity to it. The first time that most jurors hear that as a measurement for deciding a case is during the course of the actual case when they're on jury duty. So they don't have that same familiarity. The state's position is and will remain that by giving essentially the opposite side of that coin, that helps the jury decide what otherwise could be a, I don't want to say amorphous, but a oftentimes difficult standard to apply with any level of certainty. So by giving them the opposite of of reasonable doubt with abiding belief, that is the opposite side of that coin, that helps give them another means for discussing with each other if they have a reasonable doubt. I would ask the court to provide that as additional definition for them to help them make that consideration. It is appropriate, it is not error, and I think it is helpful to the jury.
Thank you. Anything further, Mr. Leary? All right. First of all, Mr. Leary raised the issue as to when I gave my opening information to the prospective jurors, to the entire panel, I give them what I tell them is a definition of reasonable doubt. And Mr. Leary is correct. I did not read the abiding belief language, and I don't ever include the abiding belief language when I give that just general definition to a jury. These are the jury instructions, which are different than the court giving a jury a general idea of how reasonable doubt is defined. And I would posit that no one will remember, first of all, exactly what I said at the time of those instructions. But the reason I don't give the abiding belief language is that I don't want someone who is a defendant to feel that they cannot suggest that if I give it, that means it will be in the final instructions. I want both sides to have an opportunity to argue that to the court. And so I don't want to read that on the off chance that someone would remember that they heard it differently. That's why I don't include it. It allows both sides the opportunity to argue to the court at the time of instructions whether or not I should include the abiding belief language. And I don't like to have a policy as it relates to jury instructions. As it relates to how I give jury instructions, I don't think that's appropriate. I think the court has to decide every time what are going to be the appropriate instructions in this matter. I find, and as the lawyers have properly indicated, if the court includes the abiding belief language, according to our pattern instructions, that's appropriate language and consistent with the law. If the court did not give the abiding belief language, that is also an appropriate instruction and consistent with the law. I am persuaded that it is appropriate, and I will include the abiding belief language in instruction 4. Any issues with 5 through 7, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Larry?
Who is this dude?
Ms. Stone, any issue with number 8?
Who dat?
My question, if it was necessary, Your Honor, in terms of the state going back through the evidence, I saw statements obviously that Mrs. Ali had made, which had come in, and statements that Mr. Ali had made, or I guess not made, but referenced in terms of arguments between his daughter and students at the scene, but not as it relates to each other, or that necessarily discussed the actions of each other, as the state's position is that Mr. or Mrs. Ali did not reference really her husband's actions at all. Her husband was referenced only in terms of what people were doing to her husband. So I don't think that it's necessary, and I think that it could be confusing to the jury in terms of how they identify what is happening in the case. That instruction number 8 is essentially a rule to address Bruton, and we don't have those types of statements here. There's no confession statement that implicates their co-defendant in terms of behavior. So I think this instruction number 8 is confusing, and I don't think it fits in this case, even though it is a co-defendant case.
All right, thank you. Mr. Kading?
And Your Honor, I don't know what the final argument of the government is going to be, but I think that this instruction is necessary because I know there has been references to statements she made after this event that the state has been eliciting from the witnesses. Obviously, Mr. Ali was part of those.
Bless you.
So I think it's appropriate to limit the statements that she made to be.
Oh, that's right. That's the dad. That's the boyfriend's dad.
Against her.
Y'all, I'm having a blonde moment this morning. My brain is not engaged. My brain is still in that wonderful, soft, plushy, warm, cozy bed. Get out of bed, brain.
Not against Mr. Ali, so I would ask the court to include it.
Mr. Larry?
No.
Well, I can think of one example. One, I think it was Officer Bell, who was Sergeant Bell, said that Mr. Ali told Mrs. Ali to just go home, given that my client is charged with burglary and has an argument that she had been trespassed. That statement shouldn't be used as evidence of the burglary or trespass as to why. I didn't get a chance to cross him on why he wanted her to go home, because she wasn't supposed to be there, or just because the event was over and just go home. So I do think that instruction is sort of good.
And so I'm not making that argument. So insofar as that's helpful, I don't think that applies that burglary plainly was committed prior to that statement being made. So I understand that concern. That's not an argument the state's making or would make, and I don't think that makes that instruction applicable. Yes. My concern is that Mrs. Ali describes what she sees as it relates to what is happening to her husband. My concern is that whether the jury looks at that and says, well, then do we need to take what Mrs. Ali said she says and cut Mr. Ali out of those observations altogether, even though it doesn't address any behaviors done by Mr. Ali. In fact, it's completely silent as to behaviors by Mrs. Ali, or excuse me, Mr. Ali. So that's my concern, is that it's
Monday.
confusing to the jury in terms of how they apply it to Mrs. Ali's statements about her husband.
What specific statements are you concerned about would be confusing to the jury if this instruction were given?
Monday.
Commissioner, my concern is that
Yeah, she didn't want the jury sitting on this over the weekend, so the closing arguments will be Monday.
the way it implies is Mrs. Ali very specifically says she rolled, I said rolled up, she doesn't say roll up, but she and Honey arrived.
You never know. There may be a
and
holdout.
that she is watching a student beat her husband. They're punching him over and over and over again. Those were the statements that she continues to make. My concern is that the jury, in reading this instruction based on essentially the nature of it, that somehow then they have to pretend she doesn't say Mr. Ali and it's just a person or someone else, that they shouldn't use it that way. But because of the way that it reads, my concern is that somehow they will neutralize and take Mr. Ali out of that statement by Mrs. Ali, even though it's not attributing any actions to Mr. Ali, and there's no statements regarding a confession or conspiracy whatsoever. So that's the state's concern. I don't think it applies in this case for those reasons, and I think it can be confusing to the jury.
Mr. Larry?
The state said that they weren't going to argue, but that's not the only standard. You are telling the jury how they are to weigh the evidence and how they may use the evidence. And just because the state doesn't make an argument with respect to the burglary, it doesn't mean that the jury might not use Mr. Ali's statement.
All right. I am going to give instruction number 8. I think it is appropriate under the evidence that has been presented in this case as it relates to statements by the defendants. I do not believe that it's going to limit the state in how they can argue their case and the facts that have been presented in this matter as it relates to each of the defendants. Instruction number 9, the last clause of that instruction or of a third person was included in the instruction offered by the state and Mr. Kading. That clause was not in the instruction offered by Mr. Leary, and it appeared to me that it doesn't apply.
The state agrees with Mr. Leary's instruction, Your Honor.
All right, Mr. Kading?
I do too, Your Honor. I only included it because it wasn't bracketed, so I agree it's not relevant.
So what I have bolded in the draft instructions will be deleted. All right, Ms. Stone, any issues with 10 through 12?
Only on 10, Your Honor, I would indicate, I think we need a, he or she does any act that is a substantial step.
All right. If I add or she, any issue with that instruction, Mr. Kading? Mr. Leary? All right, and I didn't ask you, any issues with 11 or 12, Mr. Kading? Mr. Leary? All right. Any issue with number 13, Ms. Stone?
No, Your Honor.
Mr. Kading?
Sorry for the squeal.
No.
Mr. Leary?
Yes.
All right.
So I guess at the outset, as evidenced by the pretrial brief and representations, the state had previously indicated, despite what was in the amended information, that they were not proceeding.
I've been thinking today's Friday all day yesterday.
I reached out.
Hello, Chestral Force. How you doing, Chestral Force? We're glad to have you.
Or was this included in error? And they indicated that they did intend to offer this with respect to the attempted murder. And the specific explanation was based on Ms. Wagner's statement as to the actions of my client in terms of that she saw mom striking the man. And so her testimony was different from that, but regardless, I don't believe that there is, so I just want to be clear that the accomplice liability applies to the attempted murder. Is that correct from the state
Yes.
perspective? And only the attempted murder. So operating from that. So
No, I mean, she's charged as a principal or accomplice several times. If we're talking about the attempted murder, which I understood the question was, then yes, it applies to the attempted murder, and she has been charged that way consistently. I think that there are two theories that the jury could apply it on, either as a principal or as an accomplice, but both of those are available to the state. And while we did discuss very much earlier on in the case, a different scenario that much later in the case, as we talked about it, Mrs. Wagner's information is different. And I think the testimony at trial is consistent with the charging, and the state intends to argue that as well. I think there's two theories that the jury could find that on based on the testimony that has come out at trial.
I think we're on the same page. I wanted to be sure that I was only talking the accomplice theory, in addition to the intentional theory on the murder two, is the only, the count of attempted murder is the only account where the state is proffering an accomplice, not the assault two or the unlawful. Is that correct, or am I incorrect?
I think counsel is incorrect. I think that both of those apply. I think the stronger argument, certainly for both of them, for the state is the principal, but I think the accomplice liability applies for both. The state would be arguing both of those as charged.
Okay, that's helpful. Thank you. question then becomes, in the instruction, is there sufficient evidence for the jury to consider my client as an accomplice? And I will start with the attempted murder too. If we look at the video, we know. that
Sorry.
In Exhibit 34, you can see at 213, you can see the Honda Element going the opposite direction on Mullen Road from the bus. And it then turns, the bus then parks, and then the Honda Element turns into the parking lot. The Element is already turning into the parking lot while the initial physical confrontation between Mr. Ali and Isaiah Williams, and can see the initial confrontation. So she then pulls into the Haneen pulls into the parking lot, and on Exhibit 114, which is the Timberline High School video, we can then see her running across the parking lot. And there's been no testimony as to what is visible from there. We can surmise the distance. We know there are cars that she's running around, and that there are kids surrounding Mr. Ali, Fatima Ali on the ground. We then look at Exhibit 89, which was discussed yesterday, admitted earlier in trial, which shows the arrival of my client standing next to the truck with the large Douglas fir tree in the middle of that still shot exhibit. So we know there's been no discussion about a conversation between my client and her husband about solicitation, a direction, commanding, encouraging, or requesting Mrs. Ali to commit the crime of attempted murder. There's no testimony that she agreed to aid in the planning of the commission of the crime. So the sole question is whether or not she aided Mr. Ali in the allegation that he committed attempted murder. We know that mere presence and knowledge of criminal activity, so more than mere presence and knowledge of criminal activity, must be shown to establish that a person who is present is an accomplice. That's in the instruction. So, and then there's case law that talks about it's not should have known, it's that they actually knew. Now, the state has made a large effort, or has addressed this topic repeatedly, that at no time did my client tell the police, talk about strangulation, or talk about or seeing her husband strangle Fatima. She talks about the repeated punches to his head over and over and over again. Furthermore, the court is well aware of the positioning of everybody. So we have Mullen Road, we have Fatima on the ground, we then have her dad either on top or laying in between Mullen Road, so Fatima, Mr. Ali, and the school, the direction in which she's coming. There's been no testimony that in terms of what was visible from the parking lot. There's no pictures or evidence that detectives went afterward to basically show what is visible from the parking lot. There's nobody says it was very clear from where I was standing next to the truck or between Mr. Ali and the truck that it was very clear that.
Okay, it is saying right now that Hogan or Terry Jean Bollier died after cops and EMPs were called to his home in Clearwater, Florida at 9:51 Thursday morning. He was hospitalized previously. He had been hospitalized. So he was hospitalized prior, but 13 minutes ago, reading. Okay, so this, I don't want to go through the whole Wikipedia. So Hulk Hogan did die this morning. He did have some health issues, was hospitalized in the previous weeks. Although his manager denied any medical issues, he did pass away this morning at 9:51 when the EMPs did arrive and the police, and they were not able to revive him.
What was happening? What she says is, I could see him being struck in the head by
Browning.
Isaiah. So the state has to prove that she has actual knowledge that he was attempting to kill her, and that she then, with that knowledge, agreed to assist in the commission of that crime. And there simply isn't sufficient evidence for the jury to be instructed on attempted murder 2 as to as to attempted murder. So then the next question is, as to assault 2, with respect to strangulation, same argument. You know, she comes up, and we know from Mr. Wagner's arrival, he comes from one side where he can actually see Fatima, intervenes, and his testimony is Dad immediately, he removed Dad's arm with some force, but there really wasn't much of a struggle. And he basically was able to immediately stop Mr. Ali and the actions of Mr. Ali. So then we go to the unlawful imprisonment. Now, the court noted yesterday in the halftime motion that strangulation isn't a part of reasonable parenting, but we have to look at it again from the eyes of my client. She sees, presumably, we don't actually even have testimony that she did see or could see or made eye contact, but
You didn't put your client on the stand, so you can't say crap of what she did or didn't see. Why could you even refer to anything of such if you didn't put your client on the stand and she didn't testify? That's on you, boo. You can't argue that.
there's an argument circumstantially that she was able to see her husband and able to see her daughter as they passed by the bus stop on Mullen Road. And in the video 34, there is nothing that's happening at that point. There's been no physical struggle. There's no punches. There's no strangulation. So she pulls into the parking lot. She knows presumably where they are because that's where she ran. There's no testimony that anything that happened beyond those kids is visible. She then runs through cars, sees arms punching her husband's head, goes into the crowd, same time Wagner stops Mr. Ali. She then grabs her daughter. So in the split second that this all happens, mere presence and knowledge of criminal, more than mere presence and knowledge of criminal activity must be shown. If we're talking also about, self-defense, we talk about mistaken belief, right? Which is a somewhat analogous here. There's nothing to suggest that he says, I'm going to kill my daughter. And that was the purpose of going to the school. So there's nothing to suggest, again, that solicitation, command, encourage, request. The only issue is whether she aided him in attempting to kill her daughter in the fraction of a second where she arrived with Mr. Wagner and he diffused. There isn't a basis for accomplice liability. Now, the state is also arguing, and I'm not arguing for a halftime motion, as that the actions of my client as she's holding her daughter, the state is alleging assault 2 for that and unlawful imprisonment. And I'm prepared to argue to the jury against that, but to say that she is an accomplice to what happened before she arrived and in the fraction of a second that she's there, I think is an abuse of the accomplice liability statute and legal theory.
I think if you wanted to argue all that, why in the hell did you not put, June, thank you. Yeah, they will. All of it will go, and I'll let you know at the end of the month. Guilty. I think we've raised like $700. I think we've done about $700, y'all. Y'all are freaking the best. Better than all the rest. Better than anything. Y'all are the best. I mean, simply, you really are the best. Thank you so much. You're simply amazing, June. Thank you.
Thank you, Your Honor. Your Honor, counsel, if
So what I want to know is if both of them are arguing things that they can't, they shouldn't be able to argue. If I was a prosecution, I'd be objecting like crazy. They did not testify. You cannot put there and say, this is what they think. This is what they said. This is what they did.
his argument says that she sees her husband being punched repeatedly. We saw that from the arguments, or not, excuse me, the arguments, the body cam video of Mrs. Ali's statements that she sees her husband being punched repeatedly over and over and over again. She in fact demonstrates that to Officer Chavez over and over and over again. Those punches can only be happening while her husband is strangling her daughter. Josh Wagner, who quite plainly gets there after Mrs. Ali, that is on video. That was also what Mr. Leary just indicated in his argument, because that's consistent with the video. Mrs. Ali arrives not long before Josh Wagner, but just before Josh Wagner. Josh Wagner, who knows none of these individuals from Adam, immediately says, as he's walking up, he can see that this man is strangling a young girl. Initially, as he is stopping his vehicle, he believes it is a a group of kids fighting another kid. He says as soon as he's out, he can see that it is a man strangling a child. Mrs. Ali arrives at that scene just prior to Josh Wagner, not long prior, but just prior. And instead, she, who knows both of the parties, she obviously knows where she's going to get to that bus stop in the first place. So she has communicated with her husband in some way. That is the state's argument, because otherwise she has no way to know to go to the bus stop from where she is sitting, even by Mr. Leary's own argument, out in the parking lot, if that communication has not happened. So of all the people there, even if she knew none of that, she knows who those individuals are. And so everybody there who doesn't know anyone else from Adam clearly sees and testifies immediately that they can see a grown man strangling a child. Mrs. Ali arrives on scene, and instead of assisting her child, immediately starts pulling and striking the children that are there to get them away from her husband. And all of her concern is about her husband. So she's already on the ground at the time that happens. She absolutely is an accomplice to that attempted murder. She is not helping her child. Counsel can make the argument that he doesn't believe the accomplice liability theory applies, or that the state has not met that burden. But all inferences should go in favor of the state, all of those reasonable inferences, and it should be provided to the jury to make that assessment themselves. Certainly, she is more than simply on scene and present. That application actually, in this case, would apply, I would argue, to the kids who are videotaping, to the people who are watching and don't know what to do, not Mrs. Ali, who immediately jumps in, inserts herself, and is not there to assist her child. It does not appear based on the testimony that we have received. So the accomplice liability absolutely is appropriate for that, for the unlawful imprisonment as well, because then immediately upon being released, despite all the information to the contrary from the spectators, she immediately goes into choking her child as well as restraining her child while her child is trying to get away from her, in exactly what everybody else says they saw and that she was there at the same time to see. Everybody identifies that after Josh Wagner does whatever Josh Wagner does to restrain Mr. Ali and have Fatima released from Mr. Ali, all of the striking stops. That is consistent with the video. So if Mrs. Ali is there to see repeated strikes over and over and over again, then she is also there when that strangling is happening of her child, and she knows those parties better than anyone else. So the accomplice liability absolutely should be given in that case.
Mr. Lurie, anything further?
I'll leave it up to the court. I think I would encourage the court to go back and watch the short clip in 34, where you see the arrival of Mr. Wagner and you see the arrival of my client. If you have questions as to the representation of the parties as to what my client did and what appeared to be visible to her.
All right. certainly the court viewed that clip, which I believe was played multiple times during the course of
Yeah.
the trial, and so I'm familiar with what I saw during the course of the many playing of that video, and I would posit that I saw more and more as I watched it time and again, based upon the questions that were being asked of any particular witness who was viewing that footage. Certainly, as it relates, the information, which is not ultimately controlling as it relates to the jury instructions, it's whether or not there has been evidence presented if with inferences, with reasonable inferences to the state, whether or not an instruction would be given, even regardless of how how the matter is charged within the information. I do find that there is sufficient evidence, and when I view the evidence with reasonable inferences to the state for their arguments of accomplice liability as it relates to Mrs. Ali, as has just been argued on the attempted murder charge, the assault in the second degree charge, and then I don't know if you want any further argument as it relates to the unlawful imprisonment, but I also would, it's all of those things are linked together in the time frame, and so really I find that there's sufficient evidence with all reasonable inferences for the accomplice liability for all three, for the attempted murder, for the assaults too, and for the unlawful imprisonment. And so I will be giving instruction number 13.
Well, you lost that one, defense.
On number 14, the WIPIC indicates that when there is an attempt, that there needs to be an elements instruction separately delineating the elements of the crime. The state proposed number 14. When I viewed that, it appeared to me that the last two paragraphs in the proposed instruction are not appropriate because only the elements, by my reading of WIPIC 100.02, should be included in that instruction. So, Ms. Stone?
No objection to that, Your Honor. State agrees with that deletion. I would also ask, essentially, anywhere it says FIA at this point, we just, based on the way the testimony came out, that we just change it to the name Fatima Ali, and date of birth obviously isn't being needed, excuse me.
And
And
so,
that will be throughout the instructions.
all right. Mr. Kading, as to instruction 14 with the suggestion that the last two paragraphs be deleted. Up in the first paragraph, it still says the elements would need to be proven beyond a reasonable doubt. So that is still part of the instruction.
Correct, and I agree with the court's analysis on that.
All right, Mr. Larry?
I agree with the deletion of the last two paragraphs. I have no objection to using Fatima Ali. I would object to the inclusion of her birthday because I think it's a common on the evidence to establish her age.
No, I said not to include it.
So if the court didn't go with your suggestion, I would note an objection. And then with respect to element 1 and 2, it says a defendant. I would ask that it say the defendant. My concern is that if they were to convict one defendant, it would necessarily result in the conviction of the other.
Ms. Stone?
I don't think I have an objection to that.
All right. And Mr. Kading, any objection to me using the name Fatima Ali and removing the date of birth?
No, Your
All right. Any objection as it relates to the defendant versus a defendant in elements 1 and 2 of instruction 14?
No.
Um, Any exception on 15, Ms. Stone?
Yeah, I think it needs the principal or accomplice language in element 1, that the defendant, that on or about October 18th, 2024, the defendant, and then I think it should be inserted, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step. So I think that language needs to be inserted in there.
All right. And this was your proposed instruction?
It was, yes, Your Honor, it just got left off.
All right. And so just so that I have what your proposal is in full, after the word defendant, as a principal or as a accomplice?
Yes, Your Honor, both of those set within commas.
Okay. Mr. Kading?
Now I'm confused. So are they alleging that the defendant, Mr. Ali, was an accomplice to his wife's actions?
It's
This
charged,
is
I
his
think
instruction, right?
it is his instruction. I think that it is charged that way. I think that the state is alleging it at, not I think, the state is alleging it as a principal, but I also don't want the jury to get confused when they are listening to Mrs. Ali's, that somehow they have to decide that one person is something more than the other person. And I think that that language is appropriate in that, because it is irrelevant in terms of if they believe, if for some reason they believe that he is an accomplice over a principal based on the information, I don't want them to get tied up in that language. So that is an appropriate statement, and the state is arguing primarily that he is a principal, but that there is a concert of action between the two of them at the time these events are going on.
Mr. Kading?
And Your Honor, I don't know, based on what we've seen, how his actions, which were his own, he then is laid flat on the ground, not moving. If there's an allegation then that she did something, I don't know how he's an accomplice to what she's doing. Similar to what Mr. Leary was arguing, except my client being there and prostrate on the ground certainly has nothing to do with what's going on with Miss Ali.
Your client was not prostrate on the ground. He was beating, he was strangling his daughter, and then somebody had to restrain him belly down on the ground. He was not just laying there prostrate. Prostrate, yes, prostrate.
All right. Anything further, Ms. Stone?
No, Your Honor.
All right. I am not going to, in Mr. Ali's instruction, include the language as a principal or as an accomplice, even giving all reasonable inferences to the state on the evidence that was presented during the course of the trial. I don't find that the evidence is that Mr. Ali, or it could be argued that he was an accomplice on the attempted murder to Mrs. Ali. And so I'm going to leave it as was set forth in instruction number 15. Mr. Leary, any exception on number 15? All right, then we are at number 16. Just a moment. Ms. Stone, on number 16.
Yes, Your Honor, element 1, same request of the state included the defendant, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step.
All right. Mr. Kading?
No objection to that.
Mr. Leary?
Based on the court's prior ruling, I think that assertion is appropriate.
With your standing objection?
Exactly.
Okay.
And then there is a typo. It should be element 3, not
Thank you. Um,
Honor, we ask the defense lawyers to approach the microphone, please.
Yes. Thank you.
Sorry, sir.
All right, number 17.
Prostate.
Any issue with that, Ms. Stone?
No, you're right, thank you.
I said prostrate, not postate. I was making a pun.
Mr. Keating?
No, you're right.
Mr. Larry?
Yes, Frank.
Number 18 is the definition of assault.
Now, if you're that caught up on the word, go see your doctor. He'll educate it what it is.
And
If you don't know by now, you got a
the
problem.
definition was different as was provided. It appears to me that at a minimum, the first paragraph in instruction number 18, which includes a sentence that is bolded, that paragraph would be included.
But when the doctor hits the prostate, you will go prostrate. That is how I learned it. When the doctor hits the prostate, you will go prostrate. I know it's bad.
As the definition. I'm not addressing the next two paragraphs yet.
Oh,
So, Ms.
okay.
Stone, your instruction did not
Okay.
have that second sentence in the first paragraph. Any objection to the second sentence?
No, Your Honor, it should have, thank you.
All right. And so just talking about the first paragraph, Mr. Kading, you proposed that language that the second sentence be included. And so you agree with that? First paragraph only. Instruction 18.
I don't know that the second sentence, actually, I think it's bracketed, right? I don't know that that's something that's going to be argued in this case. That it's an offensive touching. Usually we use that in a lot of other kinds of cases.
I'm talking about the language of touching or striking is offensive if the touching or striking would offend an ordinary person. I'm pretty sure you proposed that language. If you're not proposing it,
I'm looking for my instruction package.
This lawyer sucks. If this guy can be a lawyer, I need to become one. I bet his paralegal does all the work for him.
that's not true.
Okay.
You did not propose that language.
Okay.
You proposed just through the end of the first sentence and then nothing further. Apologize for that. That was language that was proposed by the state. They gave the entire 35.50 WIPIC instruction. And so you want just the first sentence,
Well,
or that's what you believe is appropriate under the evidence is what I
I
mean.
think that that's what we're talking about is a harmful touching, not an offensive touching in paragraph 1. Their allegation is that there was actual bodily injury. So paragraph 2 talks, can I move on to paragraph 2? I'm sorry.
No, we're just talking about paragraph 1.
I don't think there was any offensive touching in this case.
I'm not touching that with a 10-foot pole. I could, but I'm going to let that
Aren't
go.
you arguing that, or aren't you going to request that I give an instruction that this was discipline or that
Honey, are you doing okay?
could be a defense? And so isn't whether or not the touching is offensive associated with, it's not an argument related to your request that it was
Yes.
a defense?
Now that you mention that, that on the assault 4 would be an appropriate definition.
Well, all right. Mr. Larry, any objection to including the entirety of just paragraph 1, including the language that I have, that one sentence that's bolded for instruction 18, just paragraph 1?
Make sure when you go up to the top of your chats, it's on live chat, not top chat.
All right. So as to instruction number 18, the entire paragraph will be included.
Oh, you don't
Of course,
want
will be
me to.
unbolded. Now, as to the Second, the second paragraph is to be given in cases involving an attempt to inflict bodily injury, but not resulting in battery. That does not appear, from my perspective, to be what the evidence suggests, and that was, that language is not proposed by defense, it is proposed by the state. So Ms. Stone, I would like to know why you would want that included.
Yes, Your Honor. Your Honor, when we talk about the assault for, I want to make sure, because we've spent so much time during the course of this case with Fatima, that all of these injuries have occurred. So when we're talking about the assault, those additional paragraph instructions make it very clear that when the jury then moves to look at the injuries to Isaiah, try and decide what level of injuries, if they're sufficient, if there's in fact injuries, those two follow-on instructions make it very clear that for the purpose of assault for, no bodily injury is required. The state does not have to prove that bodily injury exists. And that helps clarify that for the jury, because we've, like I said, we spent a ton of time talking about the nature of the injuries to Fatima. And there is obviously a significant distinction between those two. I would also indicate that Mr. Keating introduced photos that certainly look different, I think, from the states, or maybe arguably look different from the states. And I don't want the jury to get caught up in whether, well, we can't really see them here, or we don't see any, so it says that it's harmful, and we don't know that there's an injury, so therefore this assault for didn't occur. Those two additional paragraphs make it very clear that the state does not have to prove that, and that is not the definition of assault. If there is no injury that is required in that case, and so I am asking that those be provided. It helps the state more fully argue that, and I think it is helpful to the jury in making that decision.
Mr. Keating?
Well, again, I mean, we have video of a punch. It seems to me that that's covered by number one, paragraph one.
Mr. Larry?
I would object to the last two paragraphs. My concern is the confusion as to, the state wants this for purposes of the assault for, which doesn't come up until instruction 39. And looking at the to convict of 39 is they have to find that on or about October 18, 2024, the defendant assaulted Isaiah Williams. All they have to prove is an assault of Isaiah Williams in the paragraph defines assault as an intentional touching or striking of another person that is harmful or offensive. And so I think they certainly have the room to argue their theory as to why that has been committed. And my concern is that the inclusion of paragraph 2 and 3 will be detrimental and confusing to my client who is not charged with a misdemeanor assault.
Ms. Stone?
I'm confused, I suppose, I'm confused as how that would be detrimental.
Yeah,
Use the law.
how is that going to be detrimental to your client when in fact you haven't even defended your client?
As it applies to the facts in the case, would be detrimental to a defendant. Paragraphs 2 and 3 are the law of the assault. It is a definition for assault. It is clarifying information for the jury, and so it is confusing to the state how providing a correct statement of the laws, especially as it relates to assisting them for Isaiah, detrimental to Mrs. Ali when there is a clear standard for Mrs. Ali as to the nature of the injuries that have to occur, or the intent for those types of injuries to occur, whereas assault for is relatively silent about that. So that argument doesn't make sense to the state in terms of how it becomes more detrimental at all, let alone be more helpful to the jury.
All right. As to the third paragraph, I am not going to include the third paragraph. That is the language, an assault is also an act done with the intent to create in another apprehension and fear of bodily injury, and which in fact creates in another a reasonable apprehension and imminent fear of bodily injury. even though the actor did not actually intend to inflict bodily injury. No inference from any of the evidence in this case relates to that portion of the definition of assault. And the WIPIC 35.50 indicates that the third bracketed definition should be used if there is evidence that the actor's intent was not to inflict bodily injury, but only to create the apprehension or fear of bodily injury. And the evidence that has been presented in the light most favorable to the state is the first paragraph definition of assault, that it's an intentional touching or striking. And that is the evidence that has been presented, not that there was apprehension or fear with no actual physical contact. So I'm not including 3.
That's interesting.
And I am not going to include paragraph 2 either.
So he got a paid attorney and she got a public defender. What does that tell you?
The WIPIC indicates that that paragraph, which indicates an assault is also an act done with intent to inflict bodily
And the mom's attorney's doing a better job.
injury upon another, tending but failing to accomplish it, and accompanied with apparent present ability to inflict the bodily injury if
Hey,
not prevented. It is not
Ronnie.
necessary that bodily injury be inflicted. As it relates to the assault 4, there is no burden on the state to address bodily injury. It's whether or not there is, I want to get to the language. They have to prove that Mr. Ali assaulted Isaiah, defined as an intentional touching or strike.
Okay, Katie Cannon, I have my mic volume down to 1. The court volume is plastered up to 100%. The volume on the court is so low, very low, that I have gained it up on the motherboard, soundboard, through the computer, and through their feed to give you what you're getting now. I will try and talk a little softer, but Katie, I'm down 100%, and my mic is back. I'll try and come back. Please let me know, Katie, if that's better.
Striking of another person that is harmful or offensive, and the second paragraph is not consistent with the evidence that's been presented, and I don't believe it limits the state in any way from arguing their case or confusing the jury, because the other assault charges, which require more than just the touching or striking, are clearly set forth in the elements, and the court knows that the state can properly differentiate between the assault charges. So
would the court consider adding the last sentence? It is not necessary that bodily injury be inflicted at the end of that first paragraph.
Mr. Kading? So she's talking about using the last sentence in the second paragraph and putting that as a last sentence in paragraph 1.
I don't object to that.
Mr. Larry?
I do object. My concern is just, my client's not charged with misdemeanor assault, and my concern is it runs contrary to what the state has to prove for assault 2. I understand that there are individual instructions laying out the elements of assault 2, but we're then providing them with a definition that is in conflict with that with respect to the specific. I mean, I think it gets, I would just want this to be clear that we are talking about an allegation of the assault 4, and that's what that sentence applies to.
All right. To ensure, I am not going to include that sentence. I understand why the state is seeking that. Again, as it relates to the charge of assault in the 4th degree, the state's burden is to prove that there was an assault, which is the intentional touching or striking that is harmful or offensive. I do not believe that the jury is going to be confused as they go through this process and apply that definition to the different levels of assault that are alleged in this case. And I believe it actually would be a misstatement if I added that sentence to the first paragraph. I think it could be construed as a misstatement of the law by putting it together like that. All right, instruction 19. Any issues with that instruction, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Number 20.
Just changing Miss Ali's name in element.
But I like you back.
With
You gave me
that
one, I
change,
give you
removing the
two.
date of birth and putting in the name. Any issue with number 20?
Wrong
Mr.
door.
Kading?
Oh,
No, Your Honor.
Mr. Leary?
No, Your Honor.
Any issue with number 21, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right. Instruction, as I indicated yesterday, I have instruction number 22, which was proposed by Mr. Kading. He then proposed another instruction yesterday that I did actually add into my draft instructions, but it was after I had sent it to my judicial assistant to print these. And so I had not wanted to reprint everything and renumber everything. But the other instruction that was presented, the difference is that for the lesser included, it was assault in the 2nd degree or assault in the 3rd degree. And as I go through the instructions, if I give those as lesser included offenses, I would include that language in what is currently instruction number 22. So I hear argument as it relates to the request for the lesser included offenses. Ms. Stone?
Sorry, Your Honor, just to clarify, are you asking for the substantive argument on the lesser included?
Yes.
First? Okay. I think that the substantive argument on the lesser included for assault in the 2nd degree is appropriate. I believe that would be Mr. Ali's 23A.
Yes.
I think that is appropriate. I don't think that assault in the 3rd degree, however, where it's been alleged by strangulation, is necessarily.
Thank you, Ada.
Assault in the 3rd degree is not a lesser included of assault in the 2nd degree by strangulation. As the state was going through, and certainly I think different minds can differ, but as I went through it last night and was looking at it in the manner that it is alleged here, I don't think it can be the argument that only assault in the 3rd degree occurred if the jury believes the state's evidence in the way that it has been presented. I think they could believe that assault in the 3rd degree also occurred, but not that it only occurred in this case based on the argument that it is done as it relates to Mr. Ali by strangulation. So I don't think that assault in the 3rd degree is appropriate. in this case.
Mr. Keating?
And Your Honor, I think that third degree is appropriate in a case like this where clearly when you have kind of a mob of people and a attack from behind that was seen in this case from Isaiah and him having a struggle with his daughter, I think it's entirely possible that there may have been a lack of recklessness or intent, obviously, which could still leave us with, well, maybe he shouldn't have put himself in that position. And it was a negligent act that caused the assault, which would have been, what happened after he was hit. And at that point, I think that an assault 3 instruction is appropriate if it goes towards culpability and mens rea, which in this case it clearly does. If he could have known what he was doing was wrong, but didn't. At that point, he was aware of it, and maybe it shouldn't have been happening the way it happened, but it's hard to tell what any person would do under those circumstances. And I think that's kind of what the assault 3 definition gets into. What would a reasonable person faced with the exact situation, what would have happened? And I think that's where assault 3 comes in and covers it with a negligent act.
So when I was looking at
This big of a package for that little thing. I have something special. For those of you who don't know, James Avery is a jewelry company that started in Kerrville, and he is international now. But one of the big things in Texas is charm bracelets. And it is a huge thing for Camp Mystic. And I bought this charm. All the proceeds from this charm go to the Camp Relief Fund. And they have sold 60,000 of them or more, probably closer to 100,000. So this charm is to honor all the victims that have died in the flood. You can go to jamesavery.com and purchase the charm, and all the proceeds will go to the victims fund. I'm going to have it engraved with the date of the flood and the number of the deceased later. I'll have them engrave it. But that's what that was. So if you have a charm bracelet or you want a charm, you can put it on a chain, be on a bracelet, to support my community through this horrific experience and to help the families that have lost everything. Go to jamesavery.com. I am not sponsored. I bought this. I don't buy things like that very often, but this was something that I felt led to do for me. Thank you.
issue, your proposed language is for the assault in the third degree with criminal negligence causes bodily harm to another person by means of a weapon or other instrument or thing.
I'm doing wonderful today. I did not go dance the Coyote Ugly last night. I went and helped a friend organize and fill out paperwork.
Thing likely to produce bodily harm. Clearly, there's no weapon that there's been any evidence of any weapon. I don't know. I didn't see any evidence of other instrument. Instrument is defined in the Oxford Dictionary as tool or implement. I did not see a tool or implement. And then it says, or thing likely to produce bodily harm. And of course, other instrument and thing are not defined in the WIPIX, which is why
I wish I could dance like that.
looked up the definition of these terms in the dictionary. And thing is defined in the Oxford Dictionary as an object that one need not, cannot, or does not wish to give a specific name to. And so,
I don't know if it's helpful. I apologize for interrupting the court, Your Honor. State versus Altman very specifically says that your arms and or hands do not constitute an instrument or thing that is actually out of Thurston County. And so insofar as that is the concern, whether arms or hands would constitute that or meet that definition, they do not. So as it
well, just let me stop you there. That's what I was getting at and asking Mr. Kading as to why he believes that this instruction would apply under the facts, because you did not argue that initially when.
I did not, I apologize, Your Honor.
So here's the charm, you guys. From between now and August 4th, 100% of the proceeds deep in the heart of Texas charm will be donated to the flood relief efforts in the Texas Hill Country and surrounding areas, not just Kerrville, but everybody in that was affected in Texas. If you, it was not delayed 6 weeks. They've hired a bunch of people. They're pushing those babies out. But this is the charm. You can go up here to JamesAvery.com. Not sponsored, but I'm putting it out there.
And I may have incorrectly put in the weapon or other instrument language. And I would agree, there is no weapon or other instrument.
So your proposed instruction did specifically say by means of a weapon or other instrument or thing likely to produce. And so that is in what I have is, that was on the 1 page,
Right.
separate sheet instruction A. So now you are indicating that, what are you indicating your proposed language is then?
It would be a person commits the crime of assault in the 3rd degree when he with criminal negligence causes bodily harm to another person with accompanied by substantial pain that extends for a period sufficient to cause considerable suffering. And it appears that that would be consistent with what the medical records show. If we consider, I guess it depends on what a period sufficient to cause suffering is, and if it's 3 days, then, or 4 days that are noted in this case, then I think that would be an appropriate.
And I do have an unpublished case that I think addresses that, Your Honor. Again, obviously it's unpublished, and so if that's helpful to the court, it's State versus Brown. The state's reference is Lexus, so I apologize to the court, but it's 28. Well, I can print it and provide it to the court. But the file number is, oh, it looks like there's a Westlaw reference too, excuse me. 2018 Westlaw 4959959. And the request, that was a assault in the 2nd degree case by strangulation. The proposed request for the lesser included was with criminal negligence causes bodily harm accompanied by substantial pain that extends for a period sufficient to cause considerable suffering. So what Mr. Kading has offered here, and that is that was a Division 1 case, and the court there said to be entitled to an inferior degree offense instruction on this type of 3rd degree assault, the evidence must affirmatively establish Brown did not strangle Guntow that caused her bodily harm resulting in substantial pain. The court went on to identify the evidence from witnesses who testified about the strangulation, and the court essentially said that the evidence does not show that Brown committed only the inferior degree offense of 3rd degree assault to the exclusion of the greater offense of 2nd degree assault. The conclusion that he committed 3rd degree assault required the jury to selectively disbelieve parts of the victim's prior statements and her testimony. Disbelief of evidence of guilt does not satisfy the factual element of the test. for an inferior degree instruction, Brown was not entitled to an instruction for third degree assault. So for those reasons, I don't think it's the third degree request is proper in this case. I would agree that the second degree lesser would be appropriate.
All right. Although certainly the court is not bound by any unpublished decisions, they can be instructive to the court as the court considers different legal issues. I would like an opportunity to read this case so that I can see if it informs my decision in any way. And also I would want Mr. Kading to have an opportunity to look at that as well. And so it is 10:10, a little early, but we'll go ahead and take a recess. I know that from what Mr. Leary indicated briefly to me this morning that he has a matter with Ms. Stone, I think in another courtroom. Potentially the parties could handle that while I look at this case, and that also will give you, Mr. Kading, a chance to look at the case as well. Going to attempt to make this a 15-minute recess. I know the lawyers will attempt to do that as well.
I'll print out a copy of that as well.
Thank you.
All rise, court's in recess.
I think I'll go get, you want me, I have a cowboy hat. Hold on. All right. Y'all made me do it. You made me do it. I got 3 of these. This is one I'm going to bead. That's why this is here. I'm going to be beading that one for somebody. Uh-huh. This one here is handmade in Houston, Texas. I think I might bead this one for me. I think this is going to be mine. I got to replace my other one. So, and it fits nice and snug. Now, this is my George Strait Resistol, made in Texas, USA. It's a little big on me, so I'm going to take it in, and the rim got misshapen. But I'm going to take it in and have them fit me in it. I'm going to have them re-steam it and reshape it. But this is a George Strait Resistol. This one, what's the number on it? This is a 7 3/8. This is the same size you need, but it's a little big. Let's see what year it was made. It doesn't give me a year, but it gives me a serial number. But yeah, this is a George Strait hat, y'all. I do need them to go in and reshape it. So, just to make y'all happy, I put that one on for you again. By the way, when you store a hat, it's upside down. This is a cheater hat. You store it upside down so your luck don't run out. So I store these like that. But let me get them over here. So there you go. I made your day. Are you happy? Are you happy, Frank? Was it Frank that put that on? Who wanted me in a hat? No, I don't want that white dot in the middle. I don't want to leave it on because of that white dot in the middle. Yeah. Y'all are funny. Seba, that was you, Seba. Yep. I do look good in hats, but my best hat now gone. But it is what it is. Nothing I can do about it. Nothing, honey. So I've learned a few things about hats and that, and I really enjoy them. But boy, I have to be careful because they don't fit me just right. I's going to be living with the migraine. And I mean living with a migraine. And it won't be fun. For those of you who don't know, I suffer from migraines. I had one yesterday, and y'all were so kind and gracious to me. Thank you so very much for your understanding, your support. Use kind, use smart, use important. Use kind, use smart, use important. That is from the movie The Help. Thank you. I'll have to bead me a hat. I got to take care of somebody else's. They got to order in, and I've got to go buy the hat. I found the hat that I want, but they didn't have it in the size they needed. So they ordered it for me. So I got to wait for it to come in. So that would be a lesser charge. Where are you talking, Penny? That's more than a 10-minute break, boo. Now we're caught up. They do not have any expressions. Yep. So let's go ahead and go to this real quick and listen to Colby.
Thursday night, I went to sleep and woke up with a really bad headache. So I had a mini stroke on Thursday night. I woke up, my arm was dead. I literally had my arm like this. Couldn't move it, couldn't do anything with it. And so after I had that, then my face, I was talking to Kelsey, my face just drops. And I'm trying to talk to her. And I couldn't say words. I just had my whole face drop. I started speaking, and like my brain knew what I wanted to say, but it just wouldn't come out. It couldn't come out. I physically could not get myself to talk. So then the ambulance was called, and they called and they came in and they started talking to me, and they were talking to me, but I couldn't respond. I physically didn't know what I was going to say. I couldn't like get my words out of my brain and into my mouth. So that was really scary. I came to the hospital. Been here since Thursday or Friday morning. Technically, I have a high pain tolerance. It was a 10 of 10. I've never felt that much pain in my head. It was all in the back. So my neck was hurting a few days before, as you guys know. Then my
That's
back, my head
meningitis,
hurt,
boo.
and then
That's what took the
just
first.
went to sleep, woke up having a stroke. And
I had viral meningitis at the age of 32, and that was the start of my hearing loss journey. And let me tell you, I told my husband at 3:00 in the morning, "You're going to take me to the ER. If you don't, I'm getting a drill and I'm putting a hole in my head." And I was not lying. As a migraine sufferer, and back then I was suffering a whole lot more than I am today. That was by far the worst headache of my life. And my temperature got to 105.9. by all said and done.
I remember trying to stand up and I couldn't push my arm
I
out.
almost died.
So after my face drooped, they came and got me. They brought me here, and they started, trying to do everything. I've had MRIs, CAT scans, another MRI, spinal tap, every medicine you could possibly think of was on there, and it was just crazy. So there's something on my head. I hate to use the word mass, but there's some type of mass right here at the top of my head. They think it was meningitis, and then they figured out it was viral meningitis. So they started giving me antibiotics and stuff like that. Just to
Yeah,
subside
usually
it,
viral
because if
does
it
not
was, then at
take
least I
it.
know I
It's
had to start on it.
bacterial, but they give you antibiotic for a viral. If it doesn't matter what kind of meningitis, you get an antibiotic, boo. Just saying, you is. So just wanted to share that. We are still in break, I believe. Let me see. We are. I'm going to start sharing some of this.
Courthouse right there. Let's take a look and a listen to see what they have to say.
The families as they answer your questions. Thanks so much.
Well, it's almost been 3 years, and today's the end of a long, hard-fought battle. But we have our person, and we have him where he belongs. So for that, we are thankful for all the men and women that put the work together, put this case together, and once it's part of the court system, it was a little ugly, but we got that conviction, and we're glad to be moving on. Glad we can move on.
Steve, the family or the judge talked about how we may never know why, and it may not be worth it to try to answer the why with something so senseless. You can't make sense of it. What do you feel about that?
There's some truth to that, but then, there's also the fact that, what would he tell as a lie as to opposed to the truth, so.
The knife, if he gave the knife up, or if he gave a part of his kill kid, if he gave out facts that only the killer would know,
it would corroborate things.
And he even addressed there's been way too many conspiracies, and the surviving witnesses had to go through hell. Well, no better way to protect them than by getting some of those details. If you got those details, then as simple as just saying I did it solo would have been valuable, I think. And we stand by the negotiation wasn't
It always is
justice. It was just a shortcut, and we said from the very beginning we're not interested in the shortcut for our daughter. And we wanted everything.
Steve, you turned the podium at one point. Talk to us about why you wanted to stare at him face down.
Because he's a coward. He's been protected by the court from day one, the minute that he was arrested. So I wanted to let him know that I was directing everything towards him, and his days of being protected are coming to an end. From what I've been explained, he gets on a van today, and he's got like 12 minute ride, and then he'll be the responsibility of Idaho State.
Were you planning on turning the podium though, or did you do that in the moment?
I remember reading it saying "do not move," so I was like, "Well, I'm moving this." I just kind of made that decision right then and there. So, I want to make it as difficult as possible. I knew my daughter was going to do a speech, and I'd heard it, and I was like, "He's going to hate this. He's going to hate this next set of people that are going to come forward and really rip into him and really expose him for what kind of a piece of trash he was." And we've been waiting a long time to say some of those things that needed to be said.
Stephen Jr., you chose not to speak. Speak now, is there
I've written up a statement. I don't know.
Yeah, maybe this is where you do it.
Okay. Well, allow me a second.
Maybe it wasn't court appropriate.
Yeah, it wasn't. Definitely wasn't. My name's Steven Gonzalez. I'm Kaylee's older brother. She was my little sister, my friend, the middle child in the heart of our family. There are no words that can fully describe her spirit. But if you knew her, you knew joy, you knew light, you knew someone who made everything better just by being in the room. My statement was largely grounded in one goal, and that was to do everything for anyone who listens to this and has to go through something similar to not have to endure what we had. My family's fought tirelessly, not just for answers, but for accountability. We've stood in front of cameras, behind closed doors, and across from people who didn't want us to speak, but we did, and we won't stop now. Across nearly every murder case prosecuted by Bill Thompson, including the killing of University of Idaho football player Eric McMillan, there is a clear and troubling pattern. Families are left feeling unheard, justice is negotiated down through plea deals, and the public is left with unanswered questions. In the McMillan case, charges were reduced from first-degree to second-degree murder, prompting confusion and outrage from the victim's family and community. The same pattern is emerged in the Silas Parks and John Lee cases, both of which prosecuted by Bill Thompson, where capital-eligible crimes were resolved through plea agreements, sidestepping trials and diminishing public accountability. The most egregious of these crimes was the brutal killing of Whitney Parks, a young pregnant woman whose life was taken by her husband, Silas Parks, during a violent domestic assault. Whitney was only 22 years old. Whitney was beaten and strangled in her own home, an act of cruelty that not only ended her life, but also the life of her unborn child. And yet, despite the devastating nature of this crime, Bill Thompson reduced the charges from murder to voluntary manslaughter, ultimately securing a sentence that allowed Parks the possibility of parole after just 5 years. There was no trial, no full accounting of what Whitney endured, no acknowledgement in the legal outcomes of the child she was carrying. For Whitney's family, for anyone who believes that justice systems should speak forcefully for victims, this wasn't justice. It was a deal, and it was like so many others under Thompson's watch. It prioritized expedience over accountability. Now, almost predictably, we find ourselves reliving that pattern in the current case. Despite the magnitude and brutality of the crime, the prosecution chose to accept a plea deal behind closed doors, without trial, without ever consulting our family in any meaningful way. In fact, we learned from the plea deal that had been finalized from an email from the prosecution team. Not in person, not with warning, not with respect. That moment underscored what we feared all along, and that this case was following the same well-worn path toward expedience over justice. Sentencing once again fails to reflect the severity of the act, and the emotional fallout has landed again on the shoulders of the victims' families, who have been left out, unheard, and grieving not just a horrific loss, but a system that continues to bypass them. The through line is undeniable. Whether it's 2004 or 2025, this prosecutional, is that a word? Sorry. Prosecutional approach has consistently abandoned the very approach it is, or the very people it is supposed to protect. The trend you'll notice from Thompson's prosecuted crimes are the following: plea bargains avoiding capital punishment, charge reductions, sentences that misalign with the gravity of the crime, lack of trial due to plea bargains. These aren't just failures in process, they're failures that have real consequences for real people. After reviewing Bill Thompson's history, it's clear our family was never given a fair chance at justice. But this isn't just about a prosecutor's record. It's about Kaylee. It's about my sister. She's not just one of the Idaho 4. She was a daughter, a sister, a best friend, and the light in every room she walked into. When the prosecution followed the same path we've seen before, closed doors, limited input, and a plea deal handed down without our voice, it became painfully clear that Kaylee was being treated just like another case. But she wasn't. She was everything to us, and our pain has only deepened, knowing that the system didn't fight for her the way she deserved. I'll leave everyone with this. There's 1,000 things I wish I could say to Kaylee, but today I'll just say this. I will always carry her with me for the rest of my life, and I will never stop being her brother.
Steve,
thank you.
Now that the gag order is lifted, is there anything that you've learned over the last 2.5 years from the investigators or the prosecutors that you can share with us now that you can speak about?
Well, I think it was kind of interesting that once the president sent a truth statement out, they called us right up and they told us everything. So I don't know what was holding them back before, but we spent about 3 hours, close to 3 hours with the lead detectives, and yeah, we found we because our main thing was we didn't want to have victims advocate statements that had lies and misquotes and misinformation in it. So I appreciate the president, putting a little bit of pressure on there, and it seemed to work. Up until that time, they told us they were not going to tell us, and we were going to have to just wait for the things to be unsealed. But yeah, it was horrific what Kaylee went through. Yeah, and I don't want to protect this guy, but I won't give out all the details. I'll be general. But yeah, she was stabbed over 30 plus times, and she was struck, and there was quite a bit of damage to her face. So this guy's just an absolute monster. Anyone who thinks that he's otherwise, I just looked at pure demons out there. When I was looking at him, we had a stare down, and he's just filled with demons. He's dark pits of eyes, and there's something seriously wrong with that man.
Steve, why was it important for you to look him directly in the eyes? And what did you say as you spoke to him?
I looked him straight in the eyes, and I just seen black holes and just anger at me. He was telling me with his face that he fucking hated me. He absolutely fucking hated me.
And why did you want to speak to him directly that way?
It's the most personal one. Like,
Yeah,
look at me in my eye. You took my daughter's life. Look at me.
Yeah,
Did your family get something today that it needed? Was this?
Yeah, 100%.
It's a little early to actually even answer that for myself. I think that kind of stuff needs to set in and sink in, and you regret maybe saying some things, or you wish that you would have said things. So I think right now we're just kind of in the mix of the tornado, and the real feelings.
As the spotlight then fades, what do you want the public to remember? Can you always get
our main thing is hopefully this could be a template for another family that, you can use the media as much as they're using you. You can use it to keep people accountable, keep people honest, keep the court system,
That's a good point.
treating you with a little bit of respect. And I think that's what we did. And the more that you get active, I think the more chance that you're going to get that justice in the end. I think you really got to try to make your kids stand out, or whoever you're trying to protect, you make them real. Get on the internet and talk to people.
Before you go, and I know you want to go, I want to ask, Olivia today was spectacular. But Olivia asked the question, what was the other weapon you used on my sister? So despite this meeting you had with prosecutors, there still sounds like there's something we don't know there. Can you explain that to us?
No, we do know that another weapon was used on Kaylee. So we don't know what that weapon was, but
They didn't recover it.
along with the knife wasn't recovered. But Kaylee was not just stabbed. There was other things that happened to Kaylee.
Talk about that a little. The conversation we had with the prosecution was about healing more than anything. It was about giving the victims' families answers. And they may share some of that information at a later date, but today is not the day for that. Today is about the sentencing. It's about putting the defendant in prison for the rest of his life. So there may be more details to come about that, but that conversation that they had was about the healing process and finding some answers that they had. And so we may share at a later date, but today is not the day. Okay?
Thank you guys. Thank you for being available.
Thanks.
Yeah, that lawyer's seeing dollar signs, and he goes, "Don't give it all away, boo. People gonna pay good money for that. You gave them the teasers. Zip your mouth, because they will pay kindly for that information." I can see a lot of stuff coming out from this, y'all. I can. And we are still waiting for them to return. I like that, using media to your advantage. Yana posted a comment I'm going to share whether she likes it or not. Get out of bed brain. Might be the cutest exclamatory I've ever heard someone say when they're having brain fog. I need attention. I have get out of bed brain. I did say it this morning. I just, my brain still, I've only had a half a cup of coffee, and it's a decaf. Accidentally grabbed a decaf. Man, y'all, I slept so good last night. Those who were just joining, I did. I slept like a baby and I didn't want to get out of bed. Yep. Yep, it did. But you know what? I've talked to somebody who was on death row, and so a lot of people on death row would rather get not a lifer, not on death row, a lifer. I talked to a lifer who's not on death row, and they said they would rather be on death row and know when it's coming than to live the rest of their lives in that environment. I thought, wow, okay. It's that bad. So I guess it depends on the person. Well, that's a possibility. But at the same time, he just saved that county and that state and this country millions of dollars. What, Ronnie? What in the world? We have all of their stuff. What? We got all the Ronnie. Oh, snap. I didn't mean to delete that. I didn't mean to delete it, Ronnie, but don't put it back up. We're good. Y'all. Oh my gosh, let me see what this is. This is the reports. This is their supplemental reports, y'all. There's 49. Here's the first one. I'll share this one. So here's the page. So these are victims, I guess. We'll go back here. Let me get another one. Okay, here's the narrative. Initial response to scene security number 171, watch guard event. Yes. What? Ronnie, go to mod chat. Okay, so let's look at this. Give me a minute to get it all. I gotta download it. Then we're gonna go to the download, open supplemental. Okay, share this page. There we go. Okie dokie. I'm going over here with it. I got to move it. It's hard to read over there. Watch guard event, yes, okay. 11/13 at 22, about 1200 hours. I responded to the 1122 Kings Road reference to a possible homicide victims. None have Noons has arrived on scene and found a total of 4 deceased individuals. Officer Noons informed other units he believed this to be a homicide. When I arrived, I entered into, I need to get this down so I can keep an eye on that. When I entered the residence, I went into the second floor. I observed a female wearing a sweatshirt, underwear, lying in the middle of the bedroom floor covered in blood. I observed a deep lacerations indicative of a defense wound on the female's hand. The female was surrounded by blood on the floor. I observed a male lying on the bed. The male appeared to have suffered from a stab wound and lacerations to the neck. The male was covered in blood and the bedding around him was soaked in blood. Wow. So what we're going to do is I just wanted to glance at that. We will do, because I don't want to get too far into it because we've got this other live, but what I might do is I might start doing a live at night and reading through all that. I might start doing that. So I will go through that on another live. That way people can choose. But wow. Y'all can go read it if you want. Okay, Ronnie, we're good.
In addition to
Knock, knock, let me in.
which was
No.
argued by Ms. Stone prior to our recess, I was also provided with State versus Coriel, 197 Washington 2nd, 397, a 2021 case by Judge Dixon from this court. I've read that now, and we'll hear any further argument. Mr. Kading, did you have an opportunity to review those?
I did have an opportunity, Your Honor, and I must admit it's a little confusing given our situation here. But it appears to me that I may have erred in adding assault in the 3rd degree and should have added assault in the 4th degree. That's what it would appear would be a lesser degree of an intentional assault. So I'm going to propose that be 4th degree.
So when you are making that argument, I think one of the distinctions that I want to hear about is these cases, both cases that were cited, discuss that the charge was assault in the 2nd degree. And therefore, they were looking at the lesser and or inferior degree charge. And it is correct that in, at least specifically in the Coriel case, the Supreme Court said that the judge erred when assault in the 2nd degree was charged, and it was charged by strangulation, that the lesser included to that charge would be assault in the 4th degree. In this case, the charge is assault in the 1st degree. And so I think the differentiation as to what is a lesser included or an inferior charge is it's the analysis to assault in the 1st degree, not assault in the 2nd degree. And so that's, if that makes a difference, that is something I would like to hear argument about.
Your Honor, when I read RCW 1061.003, it says upon an indictment or information of an for an offense consisting of different degrees, the jury may find the defendant not guilty of the degree charged in the indictment or information and guilty of any degree inferior thereto. So I don't think that the fact that it's charged first degree limits what the inferior degree crime could be.
Then why wouldn't your assault in the third degree be the correct
Well,
lesser?
we could include it
Under
as well.
that theory.
Well, I think that one of the issues has to do with the mens rea element. I mean, the intentional is an element of first degree, second degree, and fourth degree, but not third degree, because that's a criminal negligence standard. And I note in these cases that were cited, there was no, in Coriel, there was a second degree to fourth degree, and third degree was not included. And I think that has to do with the allegation that it was an intentional act as opposed to a negligent act.
So what if I'm looking at Coriel and I have it printed on pages. So I'm on page 12 of what was printed for me. I don't know if you have a printed version.
Yeah.
At footnote 50, it says, in sum, we reaffirm that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. The evidence, so I would like to know what evidence, separate and apart from strangulation, has been presented as it relates to the issue of assault, because that goes to the court's consideration.
Well, I mean, obviously there was evidence that he did grab her, and there was evidence in the video that he was touching her and trying to move her from one point to another, which could be considered an assault for these purposes. And regarding the allegations of strangulation, I think again that's something that requires an intent, which I'm not sure has been fully developed in this case.
All right. So just to be clear, you are withdrawing your instructions as it relates to assault in the third degree, and instead are requesting that in addition to the lesser included offense of assault in the second degree, which has been agreed to that there's not an objection to, and from the court's perspective, which is an appropriate instruction, you are requesting that the court give the definition or a elements instruction as a lesser included of assault in the fourth degree.
Correct, as a lesser degree of the initial charge. And I am reading in Brown where it indicates that it would be could potentially be ineffective if I did not at least ask for that to be done. So I'm asking for that to be done, and obviously that is my request.
All right. And before I hear from Ms. Stone again, Mr. Leary, this instruction does not apply to Mrs. Ali, but do you have anything that you are going to argue to the court? All right, Ms. Stone.
Thank you, Your Honor. Your Honor, I don't read either case essentially to say that once one charge has been done, we just then include every version of the lesser degree offenses. I understand now that counsel has withdrawn the assault third request and is making the assault four request. As I looked at Brown and as I looked at Coriel, and to be clear, the state provided Coriel to all of the parties and the court. the workman test is the same for each. And looking at the head note 9 at paragraph 48 on Coriel, the Supreme Court there, and I would note the Supreme Court did identify that the issue becomes very confusing at times in application, even if the theory itself is relatively simplified. Implicit within Workman's reasoning is the idea that when there is affirmative evidence from which the jury can conclude that only the lesser included offense occurred, a lesser offense instruction should be given. The court goes on to say at the end of that paragraph, the test was never intended to require evidence that the greater charged crime was not committed, only that a jury faced with conflicting evidence could conclude that the prosecution had proved only the lesser or inferior crime. The reason that it was an error in Coriel with to not give the assault 4 instruction is because that in that case there was an argument that one, the defendant had used self-defense or used force for the purpose of self-defense or defense of his property, or that 2, he did not actually strangle because he indicated that the evidence supported an inference that the defendant assaulted and did not strangle his girlfriend, in which case then the assault 4 instruction became appropriate. That does not appear to be the case here. So it's, I guess, confusing to the state why the assault 4 would be appropriate in this case, separate and apart from the assault 2 instruction as it relates to that. I don't think that we just continue to add, and I don't think Workman or Brown or Coriel stand for the proposition that we just continue to add lesser offenses each time. So I don't know that assault 4 is appropriate in this case either, based on the facts that we have, but I do believe assault 2 would be appropriate as a lesser included offense. I was looking also at paragraph 45, and just some of the statements that were made from the Workman line of cases. Quote from Gallagher, a defendant may not be convicted of a lesser degree of a crime which is included in a greater degree unless evidence is adduced to sustain a conviction upon the lesser degree. And the quote from Foley, the lesser degree of crime must be submitted to the jury along with the greater degree unless the evidence positively excludes any inference that the lesser crime was committed. It also talks about at paragraph 43 how we've arrived at lesser included offenses under the English common law. So second sentence of that, the common law rule existed to aid the prosecution when the evidence introduced at trial failed to establish an element of the crime charged. So let's say you had theft in the second degree charged, and then at testimony, instead of it being $750, somebody only testified as to $500. In that case, it would be appropriate. And I don't think that that is what we have in this case. So I don't think those are appropriate in this case as to assault 3 and assault 4.
All right, well, the assault 3 instructions have been withdrawn and will not be given. So the issue is whether or not an assault in the 4th degree is a lesser degree offense of assault in the 1st degree under the facts of this case. And I think that Coriel is the better case in its discussion, and of course it's a published case, than the Brown case, and attempted to be more clear than the Brown case as well.
Coriel is also a 2021, so it's post-Brown, and Brown did rely on that Fernandez, Medina, I believe, language that Coriel was trying to clarify as well, Your Honor.
Correct? And the test that the court is to use when giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction is given. And of course, that evidence can come from any source. It doesn't have to be from a defendant testifying, and it can include evidence presented through questions on cross-examination or evidence that is presented by the state. Ms. Stone, as it relates to Mr. Kading's argument that there is affirmative evidence that would establish assault in the fourth degree, as it relates to what was on the video of Mr. Ali grabbing Fatima and then chasing after her. He had her when she was bent over and is grabbing her in some fashion prior to any evidence of strangulation. And that's what I heard Mr. Kading was basing his argument that is evidence that would affirmatively establish, I guess, the theory that this was an assault, potentially was an assault in the fourth degree instead of assault in the first degree.
Well, I think for that to occur, that would have, for that argument to fit the case law as we have it, it would have to essentially account as two separate assaults, as it did in Coriel. Coriel case talked about there essentially being two assaults that were occurring instead of one ongoing. In this case, it's one ongoing assault. So I don't think you can argue that in the process of going to strangle someone, the second that you have grabbed them for the purpose of strangling them, then you are entitled to an assault force instruction, as if that is a separate incident from the entirety of the strangulation itself. And so I don't think that argument is consistent with the case law. If counsel is arguing that there is a separate assault, that the essentially the first time his client grabs his daughter is the assault for, and that is an appropriate instruction for that incident itself as separate and apart, then I would agree with that assertion in terms of a lesser included offense, but that it did not apply to, in that case, the second grabbing of Fatima and taking her to the ground. I would not agree that the assault for applies based on that set of facts.
Will you state that again?
Yes, Your Honor. So when we are looking at the video, there is the initial contact with Fatima where he is, Mr. Ali is described as aggressively grabbing Fatima, and that is when Isaiah tries to defend Fatima and separate Mr. Ali from Fatima. As you see in the video, Fatima falls down and she's attempting to run away, and Mr. Ali turns and punches while Isaiah is then flying backwards. Mr. Ali goes after Fatima again and puts his hands on Fatima, and then they start to go to the ground, and that is where the strangulation occurs. If Mr. Kading's argument is that the assault for is appropriate based on that initial grabbing of Fatima where Isaiah, that is appropriate. If that assault for request is based on the moment he puts his hands on his daughter to begin strangling her, that the strangulation has not yet happened, and that assault for is essentially the initial touching and it has not yet developed into the strangulation, then I don't think that is appropriate. When we're talking about Coriel, the facts in Coriel is that there were essentially two separate assaults that occurred, and the court said as it related to this other argument, the court could have determined that these markings on the victim's neck in that case came from something else and not as a result of the incident where the victim described being strangled, that there were essentially two separate. In our case, the state is arguing that this is a common scheme or plan and that there are not two separate incidents. If that is Mr. Kading's argument, then I would agree that he would have a Fourth Amendment, or not Fourth Amendment, excuse me.
I think the dad could have,
Assault in the fourth degree is a
the dad potentially could have an ineffective counsel.
lesser included if that initial contact is what he is referring to, but not if he is saying it is at the start of essentially the second contact, and therefore he's entitled to that, because certainly it goes well beyond that. He doesn't simply touch her and walk away from that. So I don't think assault 4 in that case is appropriate.
Mr. Kading?
I have no response. Thank you.
Of course he doesn't. What do I mean, Ada? The attorney for the father has done absolutely nothing in this case. The attorney for the father has put on a minimal, if zero, defense. And he's not even paying attention in court. I mean, we have caught him not paying attention. He's fumbling around. He doesn't, he's effective to a breathing paperweight. And so there could be an appellate issue, and it would be an ineffective counsel. Yeah, I think they're already past that boat, Christy. I think it's already too complicated. Oh, Frankie, Leroy.
All right.
No.
Based upon my
Hold on. Yes, Diane.
I think the jury may make their decision just by looking at the video.
Well, I mean, it's pretty evident. I mean, but
they say a picture
they have
is worth 1,000 words. We've heard.
I know, but there's too many lessers. This is getting confusing, and this is why I hate lessers. I understand you might have this or that, or maybe that, but that's it. I mean, they're going on and on. He's bored out of his mind. Look at him. He's good. I mean,
he's about to take a nap.
Look at that lawyer. He's like, I'm just earning my money. I don't want to be here.
I
don't want to be here. I'm earning my money.
Of State versus Coriel. In that case, the Judge Dixon, who's pictured here in our courtroom, was reversed. It was a case where the charge was assault in the second degree. Defense offered an assault in
He's too busy playing with the headsets. He ain't listening.
The fourth degree charge. And in an opinion that they said was to help clarify the law, it still continues to be somewhat, not trying to impugn this decision, but it is not, frankly, still completely clear. And I think that that is clear from also what the lawyers argued, that it's not clear necessarily. But the very last paragraph of this,
he could say by his religious and cultural beliefs, he does not want a female attorney.
Decision under right before section C, and it is at paragraph 50. It says that in this case, they are reaffirming that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. It's not my job to weigh the evidence or to indicate, as I put together the jury instructions, how the court thinks the evidence has been presented. In this case, I do believe that there has been some evidence that has been presented that affirmatively establishes a theory of assault in the fourth degree after reading the Coriel case. And therefore, I will give that as another instruction for a lesser crime. So I want to go back to instruction number 22 on the packet. I am going in the first paragraph.
No, Penny, I was giving my opinion. Okay, I was, Penny, giving my opinion, but I know of a case based out of San Antonio that a Middle Eastern man was given a female public defender, and he refused her based on his cultural and religious beliefs and demanded a male.
We tried to find it last night and could not.
That's my personal, but based on some.
Two lesser crimes, whether it should be the lesser crimes of assault in the second degree, and then whether it should be an and or an or. I plainly couldn't find that, and I was concerned there might be confusion as to that. So the request of the state was going to be to essentially restate that first paragraph a second time without that first sentence, so that it is very clear. So it would read the first paragraph as it says, the defendant is guilty of the lesser crime of assault in the second degree if, after full and careful deliberation on the charge of assault in the second degree, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the fourth degree. So just essentially restating that to not run into that issue of whether an and or an or confuses the jury as to application. And then the third paragraph would remain the same.
Mr. Keating.
Your Honor, I would not object to that, but I will defer to the court.
All right. That proposal seems appropriate to me, and I think will be the least confusing, will be as clear as possible for the jury as it relates to their analysis. All right. Instruction number 23. That is 23 and 23A. Those are that's the definition of assault in the second degree. And I just want to indicate that I am incorrect in the note that I wrote. The assault in the second degree under WIPIC 35.10 would, except we're using 23A, correct? I apologize. I heard about that before I started the analysis about what the lesser degree charge would be. I believe that there was an agreement to 23A for the definition of assault in the second degree.
Yes, I agree that that would be correct for 23A. If we're going back to 23 regarding strangulation specifically.
But then I don't have to.
I agree with you, Ronnie.
Oh, I apologize.
Yes, Your Honor.
I think that instruction 23A addresses
True.
both. And so I don't need to get to instruction 23, but I was incorrect about the word intentionally. I indicated in my note on 23 that it was part of the WIPIC, but it is not for the strangulation prong.
Yes, Your Honor. So agreement on 23A, if we're leaving that as it's written.
All right. And then now, Mr. Larry, you can make your argument about the word intentionally.
The other problem is that my client is not charged with recklessly inflicting substantial bodily harm.
That's correct. And it's not in part of the elements instruction either for her. The only thing in the elements instruction for Mrs. Ali is the strangulation.
Right, so I guess if we're giving 23A, do we make it clear that it only applies to Mr. Ali?
No, that's the definition of assault in the second degree. It can happen in one way or it can happen in the other way. And it's the elements instruction that tells the jury what the state has to prove as to each defendant. And it only addresses strangulation as it relates to Mrs. Ali.
So I haven't done a lot of co-defendant trials, so this is kind of why I'm just pausing, because my concern is that the definition of assault in the second degree that includes recklessly inflicts substantial bodily harm, I understand why it's being given as the lesser for the assault in the first degree, but we would never include that. If I'm standing here alone, that language wouldn't be in the definition because it's not charged for my client. And so I understand what the court is saying is to convict my client. I don't know that I'm wrong, but I just have this concern that the definition to the jury for assault in the second degree includes an alternative that my client is not charged with.
The definition defines assault in the second degree, and it indicates that for the purposes of this trial, that assault in the second degree is defined in two different ways. The elements instruction.
I'm with you on that.
Is clear as to how Mrs. Ali is charged. She's not charged, or it's not, the state does not, could not prove that she committed assault in the second degree if she intentionally assaulted another and recklessly inflicted substantial bodily harm, because that's not part of the elements in the elements instruction. But Ms. Stone?
I agree with that, Your Honor. I think the word "or" there specifically for that purpose, and when we get to the to convict, which is what the jury has to determine the state has proven or disproven beyond a reasonable doubt, that specifically addresses that issue for Mrs. Ali.
And so then if 23 is not given, so the issue is to the word intentionally.
Yes.
Thank you, Ada.
So instruction 23 pertains to WIPIC 3510, which does not include the word intentionally.
Correct.
However, if you go to the to convict,
right,
35.19.01, it does include the word intentionally. And so I requested that those two are consistent, and thus I included the word intentionally assault, even though it's not in the WIPIC as currently formulated.
All right. And that is what I would indicate, that I did understand that when I reviewed your instructions between them. But Ms. Stone.
It feels redundant because that instruction or that word is in assault already, that they will have just, I think, been instructed on. I don't know that it particularly matters, but the WIPIC didn't include it, and I assume that that is why, since it is included in the assault definition itself. So it feels redundant.
All right. I am not going to add the word intentionally to 23A. After the or, it would be, the request is that I put the word intentionally there, intentionally assaults another by strangulation. That is not in the pattern instruction. I don't have to give the pattern instruction, but there's not going to be any confusion. The definition of assault is contained herein, and the elements instruction includes the word in intent or intentional. There's not going to be any confusion, and we'll use the pattern instruction. Any issue with number 24, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
25 and 26, any issues with those, Ms. Stone?
No, Your Honor.
Mr. Katie?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right, on number 27, the proposed instruction from Mr. Kading. Just a moment here. Not sure which packet that came in. Well, I think I added the language of the lesser included crime of assault in the second degree. I believe that I added that. I didn't know if that was appropriate or not. I couldn't find the WIPIC that might apply to that.
And I think it's I'm looking at the courts, I think it indicated instruction number 27 state. I don't think the state.
No,
proposed-
it's not. It's
Oh,
not a
okay.
state proposed rule.
27A then, if we're looking at that, essentially instead, I think that is the modified.
But, Your Honor, I did not mean to hurt my daughter. I was trying to protect her from that boy with inappropriate touch and thought. I did not mean to knock her to the ground and hurt her. I was trying to hug her, Your Honor. What?
You lie. You lie. You lie.
You lie like a dog, and you were on the ground choking your daughter.
You lie like a pity in a parking lot.
Well, I'm wondering what I did see, and I don't know where it is. I can't find it again. I did see a list of abuses that were alleged to have happened in the home over time.
That question. Have they given closing arguments now and she's going over instructions?
Monday. This here is the the jury instruction forms.
That she will give to the jury. And the jury's not in there, are they?
They're off today.
They're off today. How lovely. Marchie's doing well, by the way.
You, no soup for you. No soup for you. Ow.
No soup? No soup?
Yeah. Anyway, what did you say is going well?
Margie is doing well.
Good.
She's so funny. She thinks, I'm ready to do physical therapy. I'm ready. And about 2 minutes into it, I'm done.
It's tiring.
It's very tiring. Yeah, so anyway.
Well, I'm glad she's doing better. All right, back to the grind.
35, like 3512 and 3519.01. I don't have. Oh, I'm sorry. We talked about it last night. I think the state would be requesting, as it is the alternative means for Mr. Ali. First of all, obviously Fatina's name would be Fatina Ali, and that change would be made. And so it'd be 27A using the the alternative means, but I think it should be modified in this way instead. Each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about October 18th, 2024, the defendant, it should be in 2, that the defendant intentionally assaulted, sorry, I'm backing up. On or about October 18th, the defendant on or about October 18th, 2024, 1A, intentionally assaulted Fatima Ali and thereby recklessly inflicted substantial bodily harm, or B, intentionally assaulted Fatima Ali by strangulation, semicolon, and 2, that this act occurred in the state of Washington. If you find from the evidence that element 2 and either element 1A or 1B have been proved beyond a reasonable doubt, and then the rest of the language is the same as to element 1A and 1B.
Can you print that out?
Yes, Your Honor.
And I want to make sure that I understand the proposed language. And I should have said, can you print that out, please?
I understand.
Okay. All right, so I'm going to come back to that instruction. All right, number 28 is the elements instruction for assault in the second degree as charged for Mrs. Ali.
Just the name change from the state, Your Honor, or the name spelling out from the state.
So you agree that the word intentionally should be included?
Yes, Your Honor, and it is listed that way in the book.
Yes, okay. Any issue then with 28, Mr. Kading?
No, Your Honor.
Mr. Larry?
With the inclusion of intentionally, the change to Fatima Ali.
Okay. All right. Next is instruction number 29, which is the definition of unlawful imprisonment, which is WIPIC 39.15, and whether or not the language without legal authority is properly included in this instruction.
What's the weather in Belgium like?
All right.
No objection from me either.
So that will be used. Any issues with 30 or 31, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Larry?
No, Your Honor.
32 and 33 are the elements instructions on unlawful imprisonment for both Mr. Ali and Mrs. Ali. The difference between the state's instruction and each of the defendant's instruction is what I included in here as paragraph 5. And then at the top, it would be whether or not there's 5 or 6 elements. Ms. Stone?
I would leave the state changing Fatima Ali's names in both 32 and 33. And the principal or accomplice language is
Leroy. Really? You think women are unpredictable? Did you predict this? Just kidding.
charged in each of those cases as
I'm in a mood today, y'all. I am in a mood.
well. And so I think the principal or accomplice language should be included on elements 1.
Good save, my friend. Good save. Love ya. Mean it.
All right, and any objection to paragraph or number 5?
One moment, Your Honor, please. I made a note and now I'm trying to understand my note. I guess I was, in terms of element 5, I had a question as to if we know from that the authority when you are restraining your child in the manner in which it was restrained was not is not legal. So I guess that's my question, what the intent is for defense counsel's version of it. If the argument is going to be that they had the authority to do so in that manner, that they believed they had the authority to do so in that manner, which to the state would be a jury nullification argument. So I guess my question is, why is element 5 being proposed when that is without legal authority to do so in the manner in which it was done?
Mr. Kading?
Well, Your Honor, it appears that the knowledge element would be important to include here, since it's obviously an element that regarding parents. If the state argues that the restraint was without legal authority, that's something they have to prove. They should have to prove that the defendant knew also that they did have no legal authority to do that.
Mr. Leary?
So the note on use says that element 5 should be used when facts exist to suggest that the defendant had a good faith belief that he or she has a legal authority. So parents would certainly fall within that category as to having the legal authority and whether or not their actions exceeded their legal authority as parents. And so the knowledge element should be included based on the comment and the note on use and the case law.
This lawyer for Alibaba is not doing anything. And they did not have the legal authority as parents to strangle their child.
Talking about the case law, I looked at Warfield and Johnson related to this issue, and the cases indicate that the knowledge prong, this paragraph or this sentence would only be used where the defendants had a good faith belief that they had legal authority to imprison a person. And in the Warfield case, it was the bounty hunters who picked somebody up on an out-of-state warrant, and they believed that the warrant would have been enforceable here in Washington, but it was only a misdemeanor warrant, and so it wasn't, and they were charged with unlawful imprisonment. They were given, or should have been given, this instruction because they had a good faith belief that in fact they had the ability to take this Warfield, or the person that they had come to Washington State to get, they had the ability to take that person and return them to Arizona. And Johnson, in talking about Warfield, says that Warfield is unique and does not apply to most unlawful imprisonment cases, where there is no indication the defendant believed they actually had the authority to imprison the alleged victim. You wouldn't get number 5. And so is it your argument that because Mr. and Mrs. Ali are parents to Fatima, that they believed that they could restrain her in any fashion?
Not that in any fashion, but that they had the legal authority. So specifically to the acts of my client, she had the legal authority to restrain her runaway daughter in the fashion in which she did. And that the state has to disprove that she was acting with knowledge that the restraint was without legal authority.
All right, Mr. Kading?
Your Honor, I would concur with that the parents obviously have the right to restrain the children to a certain degree. If the degree is not met, then that's the state's argument regarding why it was unlawful. So I would ask that this be included.
Ms. Stone?
Yes, Your Honor. So even by the information cited by Mr. Leary, there has to be evidence of a good faith belief. Status as parents does not create evidence of a good faith belief. There's been no testimony. There's been no indication of that in this case. Both Mr. Ali and Mrs. Ali strangled their child. That is outside the bounds. And so insofar as at least the state, and maybe it is over interpreting Mr. Leary's argument that his client believed she was able to do so in the manner in which she did. I don't know if that is intended to branch out at closing into some sort of argument of what was the norm in their household, what is a culturally accepted, or something else. Those would be inappropriate. It essentially appears to argue that, well, their ignorance of the law made it okay, and the state can't prove that they didn't have ignorance of the law, and that they decided that was a good faith belief, and there's no standard essentially provided to the jury about what a good faith belief is. So I don't think it's appropriate in this case. The manner in which they restrained her is not legally appropriate, and it is without legal authority. It doesn't prevent defense counsel from making the same argument, but that good faith belief language appears to be provided minimally and rarely at best. And in this case, the jury can make that decision based on the parental discipline instruction that I believe Mr. Leary may have proposed it as well. Mr. Kading proposed it. And that provides that information for the jury to decide whether they were acting within or without legal authority versus whether they had a good faith belief to act as they wanted to. So I don't think element 5 applies in this case.
All right. So I think I alluded to this yesterday when I was ruling on Mr. Kading's motion, I think, to dismiss the unlawful imprisonment charge. This is actually an issue that I have been thinking about as I've gone through the instructions. As I indicated, I read the cases that are cited in the WIPIC, specifically addressing this issue, and that is whether or not included in the elements instruction would be that the defendant knew that such restraint was without legal authority. And I referenced at that time the instruction 21, which is the defense to assault, that the force used was lawful related to discipline of a child, and that instruction specifically talks about that the jury may, but is not required to infer that it is unreasonable to do any of the following acts to correct or restrain a child. And that is because parents have the right, constitutional right to parent. Kids have no rights, basically, frankly, as it relates to that constitutional right, and parents' right to parent their children how they want to. Now, it can't be abusive, but parents have a great latitude to parent, and kids have no right. They don't have right to good parents. And that's why I say that kids have like no rights. But that's the state of the law. That's the state of our Constitution, and the freedoms that are provided to adults who have children. And I believe it would be inconsistent for me not to include number 5, since I have given the instruction about the discipline instruction. I do think that even though they are,
She did say they did not have the right to abuse. She did say that. So she's not saying they have the right to abuse. Other than abuse, the kids have no rights.
different and apply to different things, they are related.
She's with
and
you.
There was no indication that I'm just giving this as an example, that Mr. Ali believed that he had a basis to, I'll stop there. I think these instructions are, that one sentence and that other instruction are.
He had the right to restrain her if she felt that she was going to do something to harm herself or others, but he did not have the right to choke her.
Related in some fashion. It would be inconsistent for me to not include number 5 because the parents do have the legal authority to restrain children. The issue in this case, of course, is whether or not that was an appropriate restraint. And that's for the jury to address. So I am going to include number 5.
Thank you, Your Honor. I would ask though to confirm prior to closing and ask the court to prohibit any argument. That would essentially be a jury nullification argument to the jury at closing that these two parents in particular, based on their personal beliefs, had a good faith belief that that was okay, as if somehow in violation of the laws acting within the own scope of what they believe is okay, somehow that it's essentially a moral relativism argument. We can do what we want based on what we think is okay, even if that is inconsistent, and that somehow that then therefore qualifies as a good faith belief. I don't think that is appropriate. I also think that that is, as I said, I think it would be a jury nullification argument. I also think it brings in cultural norms that are not appropriate in this case, and we've worked very hard to try and keep those arguments out from the jury so that they're making appropriate decisions.
All right, well, there's been no evidence presented at all related to cultural norms in this family except what Fatima testified to. And so there can't be any argument that infers facts that aren't before the jury. And so I would think that neither Mr. Cady nor Mr. Leary are intending to make arguments for facts that are not in the record or a reasonable inference from a fact that is in the record. Is that correct, Mr. Cady?
Yes, Your Honor.
Mr. Leary?
I certainly do intend to explore the concept of implied bias when establishing and evaluating credibility, which, in terms of how my client is perceived, not her values justify what she did, but in terms of evaluating the evidence and talking about the instruction on implied bias.
All right, well, then I will take up objections during closing argument if the state believes that Mr. Leary is arguing something that is not supported by the facts that are in the record.
Yes, Your Honor, thank you. I think, was the court including the principal or accomplice language after defendant? I think I said it, but then we started talking about element 5 and I don't recall where we ended on that.
Thank you. Yeah, I have it. As you said that, I wrote that into these instructions. Mr. Kading, any objection as it relates to number 32, adding the language as a principal or as an accomplice?
Again, as to the to convict instruction for Mr. Ali, I'm not sure that that's, I mean, is there an allegation that he was somehow involved with Mrs. Ali? Again, I think that this is a situation where she came in after he was no longer involved.
I mean, I don't actually think that I know that that is defense counsel's argument to the jury. I don't think that's consistent with the state's theory of the case. It's also not consistent with the video. She is actually there while he is choking his daughter. So I certainly.
Political damage. She's playing this very politically correct.
Don't think it hurts.
Appeals.
It prejudices the defendant in that case. The state's ability to prove it is the same based on the evidence either way.
All right, Mr. Leary.
I don't believe the court gave the accomplice instruction for Mr. Ali on the attempted murder. I don't see how this is different.
And as to Mrs. Ali?
That's the instruction 33, based on court's prior ruling on accomplice. I think the language is appropriate.
All right.
Maintaining my theory.
All right. So as to Mr. Ali, as to instruction 32, I am not going to give as principal or as an accomplice. I don't believe that there, even with the inference to, and most favorable to the state as to the evidence that's been presented, that Mr. Ali was an accomplice to anything that Mrs. Ali ultimately did after he was no longer restraining, strangling, whatever word you want to use, Fatima, once he finally released her, once the bystander was able to get him to release her, I don't believe there's any evidence as to any interaction that he had with Mrs. Ali at that point or until much later. So I won't include the language there, but I am going to include it in 33 as it is appropriate for the reasons I've already articulated. Any issue with 34 or, well, any issue with 34?
No, Your Honor.
All right. So the definition on number 35 is going to be moved. To earlier, as it relates to the inferior matter. So number 36.
No issue on 36. Your Honor.
Except that I need to identify that that applies.
You want to put that as to count 4?
Yes.
Okay, I don't know. However, we want to word that, count 4.
So I'm going to syndicate. It is a defense to a charge of assault in the 4th degree as charged in count 4. That the force used was lawful.
Does it need to say charged in count 4 against Mr. Ali? Or do we need to, since there's 2 count 4s?
Yes, it's the same.
Do you believe that it needs to say as charged in count 4 as to Mr. Ali?
I don't think it hurts, Your Honor. I think it's clarifying.
I will add that the only count 4 of assault in 4th degree is to Mr. Ali, but I do want the instructions to be as clear as possible. With that addition, the state's already indicated no issue, and Mr. Katie, no issue. Anything from you, Mr. Larry, on that one? All right.
I do think the state is going to be requesting, though, if the court gives 36, the state is requesting that 1604 first aggressor be provided instruction as well.
Do you have that instruction?
We do have it, Your Honor. We'll print it. And we can come back to that then.
All right.
Through the other.
Also, just for the parties' information, as it relates to these instructions that we're looking at right now, I have number 37 as the instruction related to no duty to retreat. And then I have the necessary instruction in 38. I actually would give the necessary instruction. It will be moved up. It'll be before the, whether or not there's a duty to retreat if I give both of those instructions. Certainly I'll give the necessary instruction. And that was just my error in not having that be first. Any issue with number 38? Ms. Stone?
No objection to 37 or 38, Your Honor.
Thank you. And then those were your instructions, Mr. Katie. No issue. Mr. Larry?
No issue.
All right. On number 39, Ms. Stone, are you requesting that I continue to use initials?
I am not, Your Honor. I'm asking that you use Mr. Williams' name in that.
Yep. Yes.
How many instructions? We're on number 39 of the Lord's sake.
Just to changing that instruction only as to listing the name of the alleged victim instead of initials. Ms. Stone, any issue with 40, 41, 42, 43?
No, Your Honor, none.
Mr. Kading?
No, Your Honor.
Mr. Larry?
I take issue with 41, with 6503. I don't think that actually applies to the facts in this case. I think that pertains to the note on use that do not use this instruction in the usual case. I think if there's a partial, like someone breaks a window and sticks a hand in, does that constitute enter for burglary? Here, we're talking about her presence on the entire Timberline High School property.
For someone for someone who needs an interpreter and doesn't understand English, he has done nothing today but play with those headphones. He hadn't even had them on, but maybe 1% of the time.
Ms. Stone?
I don't think it hurts to have it. I would agree that following or any.
He's not wearing them.
Insertion of any part of the person's body, we could end
He could care less.
it there with a period, and the remaining clause would not need to be, or clauses would not need to be included.
All right, I did not look at that, I didn't print that particular instruction as it relates to the WIPIC. And so I want to look at that. So I'm going to have to come back to that one.
So no objection, Mr. 42. And then the court also asked me about 43.
That's correct.
Okay, I do have an objection to that.
Yeah.
So that is WIPIC 60.05, the inference instruction. Particularly the facts in this case. I think inference, note on use, the WIPIC committee says use caution in giving this instruction, see comment below. They talk about the concern about inference instructions generally. I think there's a particular concern by the defense for Mrs. Ali about the court telling the jury that they can infer that she acted with the intent to commit the crime against the person or property therein, particularly when there's a mixed motive here. The state's allegation is that the burglary charge gives rise from her unlawful entry or remaining at the school with the intent to violate the protection order. There's also an equally alternative explanation, which is why she was there, was to see her daughter, recover her daughter, and protect her daughter. And so obviously the state can argue to the contrary. I can argue my position, but I think particularly in this case, the inference instruction is improper.
Ms. Stone?
I disagree, Your Honor. I know that counsel makes that argument after modifying the to convict instruction under 46 to try and say that the state essentially must prove and add an additional element of proof to the state, which is not required by law or by statute. The state need not elect any. I think there's a number of arguments as to what crime she could be doing. First of all, she's violating the no contact order. She knows exactly where Isaiah has run. Assaulting Isaiah. She's already described an interaction with Isaiah, re-assaulting her daughter.
Did they go mute? Or was it my ears? I agree 100%, Penny. Long time no see. We're Debbie. How are you doing, beloved? Oh my gosh.
I printed
Yep,
out
they
and read
muted.
many of the WIPICs involved in the different charges that are before the court, anticipating different arguments that I thought I would hear. I did not anticipate this argument. I have not read this WIPIC. I also optimistically thought we would conclude instructions before our noon break, and we are not going to. So that'll give me time to look at the WIPIC on both instruction 41 and 43 before I rule on those issues. Number 44.
State agrees we don't need them.
All right,
We've
so
missed
that
you.
Instruction is withdrawn. Any issue with 45, Ms. Stone?
No, Your Honor.
Mr. Keating?
Nope.
Mr. Leary? All right. 46 is the elements instruction regarding the burglary in the second degree. The difference, I believe, between the two offered instructions, one from the state, one from Mrs. Ali, was that you have included the specific crime of violation of a court order. Mr. Larry, I'm going to go ahead and let you argue on that.
So I do believe I put in my trial memo that I had a question as to what was the specific underlying crime that my client was alleged to intending to commit. I did have a conversation with Ms. Stone. She indicated to me that it was violation of the protection order. If there are other crimes, then I would make a motion for a bill of particulars as to what crime, and then the question is going to be is whether or not the current jury instructions adequately inform the jury as to what crimes there are. And so I want it to be I want to know so that I can articulate and describe why my client, it's two parts: enter or remain unlawfully with the intent to commit a crime. And I think I'm entitled to notice as to what crime the state is alleging my client intended to commit as a part of the burglary.
That is one thing I don't understand. What was considered burglary?
If it's beyond the protection order, I think I want to know what it is, and I want to make sure that the jury is properly instructed as to all of the crimes that the state is going to use to argue that my client committed burglary.
Ms. Stone?
Your Honor, when we had that conversation, Mr. Leary offered me a number of options. I said, yes, no contact order, a reassault of Isaiah. With all due respect to Mr.
Look
Leary,
at that
yes,
attorney,
I
man.
would characterize his response to that as poo-pooing some of those options as he disbelieves them, but the state clearly articulated that. We are at the end of trial. I just gave a number of indications of crimes that could be provided. The case law is very clear that that is not an element for the state to prove at trial in a burglary. I have provided now multiple times an indication of arguments the state will make as to what those crimes are. I understand that Mr. Leary disagrees with those on behalf of his client, but those plainly you cannot add elements for the state to prove that are not required by either statute or case law. That is what counsel is intending to do here. It is not appropriate to put that in the to convict instruction because it is not in fact an element. And when we go to argue that to the jury should expressly know that that is not an element. And Mr. Leary cannot argue that the state has to prove that. The jury does not have to elect which of those it is. The jury has to believe, and that is why the inference language in the prior WIPIC exists.
Okay, I got it, guys. Okay, because Zahraa Ali was served with a no trespassing and told she could not come back to school. She entered the building unlawfully and remaining in that building or part of that building with the intent to commit a crime, hence means burglary. So, prosecutors allege Zahraa knowingly violated the exclusion order and entered the school premises to confront and physically attack her daughter, which constitutes the biases of burglary. Burglary is not theft, and that's where people get it
in
confused.
the first place. So it is improper to add that as an element. There is not a bill of particulars at this stage of the case to provide to counsel that I have not already provided in the argument as we have sat here.
So I would just, I'm sure as the court reviews, the court will see note on use. It may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests. That's in the WIPIC 46004. So that's the basis for the request.
What's the, I'm sorry, which WIPIC are you looking at?
So I'm looking at the to convict WIPIC for burglary in the second
Yeah,
degree.
60.04?
Yes, 60.04, which is instruction 46.
Yes.
So burglary is the unlawful entry into a establishment or home or building with the intent to commit any kind of crime. Theft is when you steal something. That I did know. Didn't have to look that one up.
What did you say the language says here?
So note on use.
Yes.
It says under some circumstances, it may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests.
And then it says burglary in the first degree elements.
It says see comment with it 6002 burglary in the first degree elements.
And then when you go down further to comment.
Trespassing is being on a property against the will or the wishes of the owner, meaning you do not have legal right to be on property. Burglary is not only being on property, but it's being on property with the intent to commit a crime, i.e., strangle her daughter. So trespassing is just standing on the property when you're not, or being on property that you are not deemed legally allowed to be on. Theft is when you just steal something. Burglary is when you are on a property illegally with the intent to commit a crime. Armed burglary means the crime that you committed while on property that you were not allowed to be on was done so using a weapon. It's an aggravator.
Under
I
crime
think,
against a
not a lawyer.
property, ordinarily, the jury instructions need not specify the crime that the defendant intended to commit inside the burglarized premises. As an exception, that crime must be specified if it is material to the defendant's theory of case. Applying Bergeron, the Court of Appeals has held a jury instruction in a burglary case should not include the elements, even if the defendant has asserted a good faith claim. And then it goes on to say there is no statutory definition of what constitutes that crime. The Washington courts have construed the requirement with a, quote, common sense, end quote, view of the underlying purpose of the statutes.
You're welcome.
To prohibit and punish conduct creating a risk of or actual harm to persons of property within a building. I have now provided that to defense counsel, again, multiple times. It is not required within the statute. It is not an additional element. The state has to prove at trial that the underlying crime has either in fact been committed or for the jury to elect which of those possibilities that they believe could have happened or she was intending to go in, does not have to elect between those possibilities of behavior. So I do not think it is appropriate.
All right, and I also do have that instruction in front of me, and I I thought I heard you say something different, Mr. Lair, which is why I had you repeat what you,
Okay, I have several people asking me, so let me clarify. The definition of trespassing is unlawfully entering or remaining on someone else's property. Burglary, unlawfully entering a building with the intent to commit a crime, theft, or assault. Intent that is required to make it trespassing. No criminal intent needed beyond being where you're not allowed. An example of trespassing is walking into a fenced yard without permission. Building or structure, no. It can be open land, school grounds, parking lot, anywhere the owner of the property does not wish you to be. Usually it's a misdemeanor, fines, community service, or probation. Now, burglary, as I read earlier, is the unlawful entry of a building or with the intent to commit a crime, i.e. theft or assault. Must have intent to commit another crime, meaning just being there isn't just enough. You got to be there with the intent of doing something, assault, kidnapping, red rum. Breaking into a home and stealing or to steal or attack someone. That is also part of burglary. You broke into the home, you were trespassing, you broke in, which is an illegal act, and you unalived or attacked somebody is a third illegal act. Is a building or structure required? Yes. So this is one of the things that really separates trespassing is under trespass, you do not need a building. It can just be open land. In burglary, it must have a structure, home, school, store, etc. The severity is usually a felony. Prison sentence from often 5 to 20 years, depending on the state law.
said. I'm going to use the instruction as proposed by the state.
I'm going to get me some kratom and wake my butt up.
Nor do these circumstances require that the court specifically indicate the language that was proposed by Mrs. Ali, that entering or remaining was with intent to commit the crime of violation of a court order. And I will not include that language. The instruction as was proposed by the state is a correct statement of the elements that need to be
Hello,
proven
Mr. Robin.
for that's the burden on the state.
He has not been listening. He's been
Number
playing with his headphones.
47. Any issue with 47, Ms. Stone?
It should have I think we have restraint provisions language should be coming after provision of the order. Can we come back to 47 and 48? We modified the language on that and we're going to resubmit that. So we'll provide those to the court.
Okay. All right. Actually, we're going to start, it's noon, or it's a minute to noon. So we will come back and address the additional instructions. Mr. Kading, since you are now offering an assault in the 4th degree as a lesser charge, I need you to provide over the lunch hour the elements as to that lesser charge. I already have the definition because the definition's already been previously provided, as well as a proposed verdict form, since you are proposing those instructions, and I don't have those.
And I do think Ms. So provided the initial request for those lesser included that maybe in the packet that she handed up to the court just a few minutes ago. So, and I think it went to both Mr. Larry and Mr. Kading as well.
I still got my got out of bed brain going. I just took something to help with that.
I see.
The verdict form would not have been in there though.
All right.
We need a verdict form for the lesser included assault or. Right?
That's what you're offering, right?
Yes.
Okay.
I'm just trying to make sure that I got it.
I don't want to create instructions. I want to use the instructions that the parties have submitted. They may be changed, but the court does not want to create the instructions.
I know we're not talking about 151, but the only question I had at the outset, and I think we'll just need to flesh that out, is whether we had enough letters for lesser included based on the number of lesser included that we're going to be given.
Right, that's going to have to be modified based upon, I created the concluding instruction with one lesser included, because at the time I created that addition within that instruction, the only lesser crime was the assault in the second degree.
And I do think you had indicated, Your Honor, to delete the special verdict form, but I do think we need the special verdict form.
I added that language later on, which is, so look at the entire instruction. That's why I thought it should be deleted there, because it's included further down in the instruction.
Thank you, Your Honor.
All right, so we will be in recess until 1:30, and then we will take this back up. Mr. Leary?
I think there's one instruction left, but I don't think it's going to be in disagreement. So I don't know if we want to hammer it out now or
No.
hammer it out.
Look at the look on her face. She's like,
I also need to look at the two. Two whippets that I talked about under the burglary charge. And this also gives me an opportunity to hopefully make changes that we have discussed as well, in case I have any questions as I'm making those changes to ensure that I haven't missed anything. So the court will be in recess until 1:30. Thank you.
all right, court's in recess. She's like, I'm out. And the jacket comes off. He's like, the jackets are off. He's like, we're good, thank you. I couldn't understand that lip read. He's too far away. But he said, we're good, thank you. Okay, Miss Diane. Diane. Polly want a cracker. She's doing something on her screen. She doesn't see me. I would love to hear what they're saying. Okay, we're done until 3:30. So, hi, Ada. Indeed, he's not listening, but he's still silently emoting. Yeah, Tinkatude, your keyboard's too small. The backspace and the inner keys are too close together. Yeah, well, that's why I got a big one. My fat fingers. Okay, let's go back to the Kohlbergers. I want us to finish. I think we finished that. So let's go back to this. I'm going to try and find us some fun things to watch. But I don't understand why they started doing the lessers unless they were saying, well, we'll get more convictions if we do lessers because it gives the jury more control over all this stuff. That's interesting. Maybe you want to elaborate on that? And where did you learn it? Somebody sent me a text. Hello, Robin. Thank you so much for joining. Yeah, we've had some interesting stuff going on today. First of all, I've got I have one of those bad get out of bed head days. It's yeah. I got that got out of head brain. I want y'all to see this. This is just too cute. This is some who sent this. All right, that was Miss June. I adore cats for that reason right there. Look at the kitty. He looks possessed. It's like that song that goes on, Dan Don, my friend. Dun, 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 dun. Yeah. I know Ronnie is going ape nuts with that because she just loves kitties. Ronnie just loves your little kitty babies. Yes, she does. I know Ronnie probably just ran out of the room. You were getting all the aided tinkitude? Oh no. And I know a lot of people are really arguing a lot about a lot of the decisions. And one of them is the decision to keep out the red room, honor red rooming and the arranged marriage, but it would really prejudice the jury, at least with the honor red room. Arranged marriage, I wouldn't be surprised with because it's cultural. Well, so is the other, but not to the severity. Cats are terrific. Okay, thank you. Yeah. So I get it. I get it. It's one of those things that you just go, huh? A Texas flood survivor gets gifted a new RV, small one, but he got gifted a new home after he lost everything. Aww. I'm looking for things, guys. Oh, might as well do this.
Cardiac arrest. He was 71 years
Everything I've been through, I want to knock somebody out.
old. Has died. Medics were called to his Florida home. Reported a cardiac arrest. He was 71 years old.
Words to describe where you are today in your life.
Centered, joyful, very forgiving.
Born Terry Jean Bollea, Hulk Hogan adopted his stage persona in the late 70s when he joined the World Wrestling Federation.
Hulkamania will live forever, man.
He soared to superstardom in the 80s as he took on endorsement deals.
I'm one of the first wrestlers to cross that media barrier in the commercials and different types of television.
And transitioned to acting.
I body slammed the whole world of Hollywood.
Cut to the early 2000s, and Hulk was a TV star thanks to his family's reality show.
If this crap was your idea, you're in a lot of trouble.
It was your idea.
Don't even go there.
He and wife Linda split in 2008 following infidelity on Hulk's part. His later years marked somewhat by controversy, from a racism scandal to a sex tape and a pivot into politics.
And they tried to kill the next president of the United States. Enough was enough. And I said, let Trumpomania run wild, brother.
He's survived by his third wife, Sky Daly, and kids, daughter Brooke and son Nick.
To my fans, thank you for being with me, for riding the highs and surviving the lows. Their loyalty is unwavering. They just know who I am, and they actually know I'm a human being.
Rest in peace, Hulk Hogan. Oh, we got some new baby memes. Let's look at
the
this.
law better than I do? The judge sneered, his voice filled with arrogance as he leaned back in his chair.
This is AI.
Silence fell over the courtroom. All eyes turn to the calm.
I don't do AI. I don't do AI. Me no do AI. Taking a break. See y'all later. See you in a little bit. We'll take a little lunch break here in a minute. Okay, we're going to watch something about Lori Daybell.
Prosecutors are asking a judge to give convicted murderer Lori Daybell 2 more life sentences. She returns to court tomorrow for sentencing, and Court TV is going to be there for it all. Matt Johnson's going to be there. Daybell represented herself back in April when a jury found her guilty of conspiring to murder her 4th husband, Charles Vallow. And then in June, she represented herself again when a jury found her guilty of conspiring to commit murder in the attempted killing of her niece's ex-husband, Brandon Boudreaux. Court TV anchor Julie Grant has a look back at these 2 trials ahead of tomorrow's sentencing.
The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you.
Lori Vallow Daybell stood in front of a Phoenix jury and attempted to convince them that she had nothing to do with the 2019 shooting death of her 4th husband, Charles Vallow.
As the state has mentioned, they are alleging that insurance money was my motive. Spouses having insurance policies is not a crime. Collecting Social Security is not a crime. Self-defense is not a crime. A family tragedy is not a crime.
No charges were initially filed, but after her children disappeared and were then found buried in the backyard of her new husband, Chad Daybell's property, Chandler, Arizona police reopened the case. Her 9-day trial involved her questioning Charles Vallow's sister, Kay Woodcock, her clashing with law enforcement, and her bullying a woman who had had dinner with Charles the night before he was killed.
Miss Woodcock, did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
Okay, you're a detective, right?
Correct.
You have to look at all the angles, right?
Correct.
You don't know what happened, right? You just stated that you weren't there, right?
Correct.
On the website that you met him, did he say he was divorced?
I'm not certain.
So you spent your whole date getting to know each other, talking about me.
Don't flatter yourself. No, we did not spend the whole time talking about you.
It took jurors about 3 hours to convict Lori Vallow Daybell. 2 months later, she was back in the same Phoenix courtroom, again acting as her own attorney.
Conspiracy is an ancient word that appears in the Bible on many occasions. Judas conspired against Jesus with the chief priest for 30 pieces of silver.
Object to
I object to you comparing yourself to Jesus, honey. As I say, you can't compare yourself to the Lord, honey. Sit down.
Unless this is being presented
Yeah, that's how some preachers talk. Just saying.
at the trial, I'm not sure that this is appropriate opening.
This time, Lori Vallow Daybell was in court for an attempted homicide case. The intended victim, her niece's ex-husband, Brandon Boudreaux.
If you felt that you had just been shot at, were you not worried about standing there in the driveway where someone could drive by again?
The person that shot at me was in the Jeep, and I had seen them leave. Of course, I was scared for my life, but I was told to go back to my house, so that's where I went.
Lori Vallow Daybell did her best defending herself and also tried the judge's patience.
Your best wasn't good enough, honey.
If I open the door, do I get a hearing? We stop trial and I get a hearing.
Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character, we're going to have a short hearing on what evidence that they can bring in to rebut that character, which could include being convicted of 4 murders. So,
and would you
talk to your advisory counsel during the break? And
you don't need to yell at me either. I'm not,
okay?
Yeah, you are, and you do not need to talk to me that way. I'm very courteous. I'm very courteous to you.
No, you have been nothing near courteous to me during the course of these proceedings.
It took jurors less than an hour to convict her. She'll be back in court one more time for her sentencing. She could receive 2 more life sentences, in addition to the other 3 she's already serving in Idaho for the murders of her 2 children, JJ and Tylee, and the murder of Chad's first wife, Tammy Daybell.
Still with us, criminal defense attorney Chase Brown and chief trial attorney from the Muskegon County, Michigan Prosecutor's Office, Matt Roberts. Matt, I'm going to start with you. Okay, talking about the sentencing tomorrow, I was just reviewing the sentencing memorandum that the prosecutor submitted to the judge. One of the things that she put in this memo, she placed a text that Lori had sent Charles Vallow's sons, in which she's just saying to them, I don't know what happened to your father. He passed away. I'll let you know when I find out more information. When it turns out she's the one that was responsible for the situation in the first place. So when you put together sentencing memos like this, what's your approach to the judge when you have someone like Lori Daybell and she's been convicted of so many murders already?
Well, certainly what you're trying to get across to the judge is that this is a person who is absolutely irredeemable. It doesn't always happen, quite frankly, in prosecution work. It ties back a little bit to the Kohberger case. There are often very few people who you can actually look at and say, this is a person who just simply cannot be trusted in society, has no place in society, and their actions have given the judge no choice. And certainly with the astounding amount of crimes that Ms. Daybell's been able to rack up over her time, as well as these 2 additional convictions, I don't think it really gives the judge any choice but to impose that sentence.
Yeah, maybe we'll hear some of the same words echoed by this judge, because when he was talking about the sentencing for Brian Kohberger, he said, I cannot find anything redeemable to say about you. And it's very possible we'll see the same thing or hear the same thing from the judge for Lori Daybell. We'll have to see. Chase, what do you think?
I think from a defense side, you always want to try and find some mitigating factors, present something to the judge to mitigate why, that your client or someone shouldn't get the max sentence or get the sentence they're going to. But in this case, she is such a danger to the community. There is no bounds that she will stay within in terms of the harm she will cause. I mean, she's gone after so many people. There's really no mitigating factors that I could even think of in this case. And the prosecution has put that forward in their memorandum. And there's really no reason that she should be a member of society ever again.
Yeah, absolutely.
I don't disagree with that.
I'm unable to come up with anything redeeming about Mr. Kohberger because his grotesque acts of evil have buried and hidden anything that might have been good or intrinsically human about him.
And with that, Ada County Judge Stephen Hippler handed down 4 consecutive life sentences plus 10 years for admitted murderer Brian Kohberger, without the possibility of parole, without the option of an appeal. Kohberger accepted his fate last month when he agreed to a plea deal with prosecutors and confirmed he killed Xana Kernodle, Ethan Chapin, Kaylee Gonzalez, and Madison Mogan in a home on King Road just off the UFI campus in November of 2022. Lead prosecutor Bill Thompson made it clear this was a plea deal, I should say, not a plea bargain, but still not a final solution all families of the victims supported. And today, several made that clear. However, today was mostly about those family and friends sharing their stories of devastation, sadness, and anger to convince the judge to commit Kohberger to life in prison. Wasn't a difficult decision, as you just heard. And for the first time today, we heard from one of the surviving roommates, Dylan Mortensen, who we learned saw Kohberger leave the house that night, though she was unaware of what he did until later that day.
He didn't just take them from the world. He took them from me, my friends, my people who felt like my home. The people I looked up to and adored more than anyone. He took away my ability to trust the world around me. What he did shattered me in places I didn't know could break.
Dylan said since that night, it's been difficult to even be alone. She suffered from panic attacks she's never had before. She slept in her mom's bed for a year. We also heard from Maddie Mogan's family. Her father, Ben, called her the only great thing he ever did, and he shared how much she meant to him in his life up until that day.
She did encourage me to
not just to do my best, but to live on. I went through a lot of issues with addiction and with substance abuse, and when I wasn't wanting to live anymore, she was what would keep me from just not caring anymore. And knowing that she was out there and that she was just such a beautiful person kept me alive a lot of rough moments. And
Ben even read from a Father's Day card that Maddie sent him, the last thing that she wrote to him. Ben said Maddie had always wanted to see a concert at the Gorge where he worked. She finally did so with her boyfriend, Jake. Meanwhile, the Gonzalez family, who have been very vocal about their objection to the plea deal, they came into the courtroom understandably angry. Kaylee's dad called his master's degree, Kohberger's master's degree that is, in criminal justice, a joke, and he called Kohberger stupid. Kaylee's sister also spoke directly to the defendant, saying she refused to give him the satisfaction of seeing her heartbreak.
I won't stand here and give you what you want. I won't offer you tears. I won't offer you trembling. Disappointments like you thrive on pain, on fear, and on the illusion of power. And I won't feed your beast. Instead, I will call you what you are: sociopath, psychopath, murderer.
And of course, the big question many were hoping to hear answered today was the why. And they were hoping to hear it from Kohberger himself. But when given the opportunity to speak, he respectfully declined. When it came time for Judge Hippler to hand down his sentence, he wanted to make it clear he felt the same desire to understand why this happened. However, he also said continuing to focus on the why just gives Kohberger relevance, agency, the attention and power he appears to crave.
Yet even if I could force him to speak, which legally I cannot, how could anyone ever be assured that what he speaks is the truth? Do we really believe, after all of this, he's capable of speaking the truth or of giving up something of himself to help the very people whose lives he destroyed?
After today's sentencing, we learned from investigators they still had no motive, no connection between the killer and the victims, no links between them on social media. We also learned from the Gonzalez family, who called Kohberger an absolute monster, that Kaylee was stabbed 30 times that night. The Chapin family, meanwhile, decided not to take part in today's proceedings, hoping to focus on moving forward. And a lot of people were hoping to do that today by being a part of these proceedings. We're bringing in Morgan Romero now because, Morgan, one of the families that we have not heard from that were there today, the Kernodals, and you had a chance to speak with them today about, well, all of this, but for a little bit of moment, some peace and quiet outside the courtroom to kind of get their take on this.
Yeah, I was able to meet with Xana's mom, Kara Northington, in private. You know, she did give a victim impact statement today in court, standing at the podium alongside her brothers. Kara tells me she feels relieved. She's glad this is over. She's glad she doesn't have to look at Bryan Kohberger ever again. She says she's now come to terms with the plea deal, saying it gives her a sense of closure. She and her family don't have to be subjected to 3 months of a very grueling trial, and she's so grateful for that. Kara made sure to look Kohberger in the eyes during her victim impact statement today, and she said all she saw was the devil himself. She saw nothing behind his eyes, and he sat emotionless and without any reaction or remorse. It's hard not to get answers or hear an explanation, but Kara believes the judge made a good point. They would never be able to believe Kohberger. They can't trust him, as you just heard Judge Hippler say, even if he were to explain his actions. She thinks Kohberger feeds into the family's hurt and bitterness toward him and revels in not providing them answers. Kara has become more religious since this all happened, and she believes that the Lord will reveal what they need to know in due time. Today, she wanted to show who Xana was and the impact she leaves behind.
Her light will shine on forever. That's something that can never be taken from this world.
What do you miss most about her?
Just her laughter. Her sense of humor was amazing. She was very funny. I miss her smile. I just miss the way she loved her siblings, the way she loved her family, the way she loved her friends, the way she just brought joy to everybody around her. And she was a beautiful human being, and her spirit lives on. with all of us.
What Judge Hippler said is like, as a parent, that's your identity, that's your existence. It's like when that's taken from you, like a part of your soul, I imagine is taken. Did it feel that way, and does it still feel that way?
It does feel that way. But as a Christian, I have the hope of seeing her again. I know where she is. I know that she lives in heaven, and I know that this is a fallen world. And we don't live for this world. This is not our home. Our home is in heaven. And I will see her again. It's not the end. But it is a part of me that will forever be missing while I am here on this earth. But I have 2 children who are living who I really needed to pull it together for. And I had not been more proud of them in my entire life.
Losing Xana led her to Jesus, as I said, and she turned her life around because of what happened. Kara told me she's so proud of her other daughter, Jasmine, and Xana's father and stepfather, who also shared just very powerful, raw, and vulnerable statements in court today. Kara told me she forgave Kohberger and started her healing journey a long time ago. She hopes that today, this sentencing, this closing of the final chapter, does the same for other families.
I believe the Cronotas were the only family that did say that they forgive Brian Kohberger for what you did. Everybody else was not willing to do that today. You were inside the courtroom.
Yeah.
Very emotional, obviously.
Oh,
What was it like to be inside there and be surrounded by that?
Oh, yeah, Brian, it was really heavy. I'm going to be honest. I think we've reported on this story so many times for 2.5 years. To put these stories and the impacts and the devastation to these names and to hear from the people whose lives will be forever altered because of this, it is really intense. And the sobs were audible. Kohberger's deadpan stare at the families as they spoke directly to him was sort of surreal. I think it was all just very surreal, very, very heavy to be in that courtroom, and just with the amount of national and international attention on this case. I really appreciated the opportunity. It was sort of a privilege to be able to be in there and humanize these people.
You saw that emotion from the prosecutor, Bill Thompson. You saw the emotion from the judge, Judge Stephen Hippler. It was very thick.
It was.
In there. And it's only going to continue, unfortunately, because Moscow Police Department, as they promised, has started to release documents that give us some more of these gruesome details of these crimes that we are just beginning to dig into ourselves. And there's a lot to go through. So when we find out some more information, and of course, give us some time to figure this out for ourselves, because again, give us some grace. It's been a tough day. We'll bring to you what we can when we can.
Yeah, I mean, the gag order's been lifted. We filed public records requests. These documents just came down. So you're also going to hear from more of those victim impact statements as well, coming up on the news at 6 and 10.
Thanks, Morgan.
So, yeah, I think it was a good way to avoid the DP. 100%. 100%. You've been kicked out 3 times today from here? Or just YouTube in general? Because I ain't kicking you out, boo. Well, I've heard the state did. I also heard that the defense had asked for a plea bargain, and the state had not denied it, but did not accept it. And then later, they decided to accept the plea bargain. I don't know. We'll never fully know. It may be in the documents that the police released. I don't know. YouTube in general. Okay. Okay. Back to Lori Daybell, because we're going to be going to see her tomorrow. I'm bringing the volume down.
Roland's in for Vidipolitan. We continue our investigation of child killer Lori Daybell, who was convicted in her latest murder trial of taking the life of her 4th husband, Charles, so that she could be with her 5th husband, Chad, and try to collect on $1 million of life insurance money. Here's the story. We call Lori Daybell the Doomsday Cult Mom. She was convicted in Idaho for the murders of her two youngest children, 7-year-old Joshua JJ and 16-year-old Tylee Ryan, as well as for conspiring to kill her fifth husband's first wife, Tammy Daybell. In July of 2023, she received 3 consecutive life sentences without the possibility of parole. Prosecutors argued that Vallow Daybell's extreme religious beliefs, which included apocalyptic prophecies and labeling her children as zombies, motivated the killings. The children's remains were discovered in 2020 on her fifth husband Chad's property in Idaho. Following her Idaho convictions, Lori was extradited to Arizona, where she faced charges for conspiring to murder her fourth husband, Charles. In 2019, Lori was also convicted for collaborating with her brother, Alex Cox, to kill Charles and claim his life insurance money. Lori was also found guilty of trying to kill her niece's ex-husband, Brandon Boudreaux. Now, Lori is about to learn her fate for her Arizona crimes. Over the years, Lori has said a lot of things, and what she hasn't really done is take any sort of responsibility. In Idaho, when she was convicted of 3 murders, including the murders of her 2 children, this is what she had to say.
Jesus knows me, and Jesus understands me. I mourn with all of you who mourn my children and Tammy. Jesus Christ knows the truth of what happened here. Jesus Christ knows that no one was murdered in this case. Because of this experience, I have access to heaven and the spirit world. Since then, I have had many communications from people now living in heaven, including my children, Tylee Ashlyn and Joshua Jackson. I know for a fact that my children are happy and busy in the spirit world. Because of my communications with my friend Tammy Daybell, I know that she is also very happy and extremely busy.
Her friend, Tammy Daybell. Let's get our first question in for the night, and it will be, will Lori come clean? Are we going to hear anything out of her in Arizona when she is sentenced later this week? Here to help answer that question is Lori Vallow Daybell's Uncle Rex Connor. He's also co-host of the podcast Silver Linings and the author of the book Lori's Lies and Family's Ties. And Arizona criminal defense attorney Josh Colesrud is with us as well. Rex, what do you think? Anything out of Lori or more mumbo jumbo?
I don't think the mumbo jumbo will stop until she dies. And so I believe she is so committed and so engulfed by the evil she perpetrated that we aren't going to hear anything else from her.
I get it.
Have you ever had a client like Lori? She ended up not even needing a lawyer. She represented herself there in Arizona, but she seemed to be directing traffic, and I'm not sure where her head is. And what do you do if you're representing someone like Lori, and how do you navigate those waters?
Sure. So if I'm her attorney, I'm probably going to counsel her not to come clean, because if she does come clean, it could negatively affect her appeal. And frankly, with Lori Vallow anyway, she's not the type of person who wants to come clean anyway, and she probably doesn't even see a benefit. She's going to get a life sentence without the possibility of parole, and it's going to be stacked. That is, consecutive. And there's no way that the judge, I think, is going to give her concurrent terms. So, she did an interview at the end of June on TV.
Very delusional.
About 40 minutes long. And I think that her sentencing hearing is going to be very similar to that interview where she said that she's not an evil person. She doesn't have a violent bone in her body. And basically that she had nothing to do with any of the murders, and that it's just a family affair. I would fully expect that she's going to give some type of sermon to everybody in a Charles Manson type of way, justifying, herself, and of course, blaming everybody else.
Yeah, and probably she's going to echo those opening statements and closing arguments that she had on behalf of herself, which were basically self-serving and saying this is a family tragedy, nothing more, nothing to see here. Rex, can you give us a sense of who Lori was when she was younger, growing up? She seemed like she was a good mother. She had a lot going for her. From your perspective, what was the other Lori like?
Yeah, I'll try to do that. We've been doing our podcast for 2 years and talking about her, and I've become more and more disgusted with the evil she perpetrated. So it's a little bit tough to go back, but
when you go back, do you see the evil Lori now in retrospect? Did you go back? Oh, no.
No, two different Loris. And so, people tell me, have told us all the time, I'm co-host of my podcast is Lori's brother, Adam, the good brother. And people tell us, well, we're naive. She was always evil. If she did this evil now, she's always been that evil. That could be. We didn't see into her heart and mind. We aren't perfect judge of people. But we saw a very happy, very positive, very loving, devoted mother that whole time. And so those were her actions. Again, not saying into her heart and mind. But that obviously changed
That
rather
makes no
quickly
sense
as
to me.
she started down a path of, choosing evil.
Josh, you don't think she should or will come clean at her sentencing hearing? What about later down the road? Do people who are in prison for a while eventually come clean, whether they are touched from religion or just have a sort of a moment where they realize they're never going to get out? So, all right, I'm going to admit it as a way of self-healing.
I would say that in the past, dealing with cult-like figures and cult murder cases, that it takes decades for that type of acceptance of responsibility to manifest itself. And I'm thinking specifically of the Charles Manson murders and those that committed the murders on his behalf. In that case, he had his followers that committed the murders, and they didn't come clean right away, but they did decades later. And if Lori Vallow is ever going to come clean, I don't think it's going to be for a very long period of time.
Yeah.
I don't either.
Let's listen to Lori in her opening statement, representing herself, saying this, nothing to see here. This was no crime.
As the state has mentioned, they are alleging that insurance money was my motive. Social Security was my motive. Spouses having insurance policies is not a crime. Collecting Social Security is not a crime. Self-defense is not a crime. A family tragedy is not a crime. It's a tragedy.
Rex, what was her motive? Was it to be with
Josh,
Chad?
close route. It cut me off again.
Looks like we have a little technical problem with Josh. Rex, what was her motive in your mind, especially with Charles's murder? Was it the money? Was it to be with Chad? What do you think?
Yes, and I like the way the Idaho prosecution laid it out. Sex, power, money. I can't remember the order that they used, but I believe it was a combination of those factors. Again, not saying into her heart and mind, but there's nothing pure about it. There's nothing good about it. It's pure evil. Sex, power, and money is consistent with that.
Yeah, there's the old video of them getting served, Lori in her bikini and Chad looking awkward next to the pool in Hawaii. We'll see what happens here. Are you anticipating anything of substance out of the Arizona sentencing hearing?
What comes of substance out of that are the people around it, the law enforcement, the attorneys, the media, all the good people around it. It's such a beautiful community that's formed around it. It's a silver lining against this black cloud, but I have very low expectations of Lori and hearing anything good about her. I hope we can all rally around her oldest son, surviving son, Colby, had health problems the last few days, needs our prayers, love, support. That's going to happen for sure as all these people get together that have formed a loving community around this horrific tragedy.
Absolutely. Well said. And yeah, Colby has been through a lot. Larry and Kay will have their opportunity to say something. And you know, they get justice in Arizona. That was part of the equation there for Charles's murder. Thanks to Josh Colesroot for being with us. Rex is going to stick around. Coming up next, who else did Alex Cox kill?
And that's when he said, I think I am being their fall guy.
Brian Kohberger accepted a plea offer.
A shocking turn of events. How do you plead, guilty or not guilty? Guilty.
Convicted killer Brian Kohberger will learn his fate from.
And that's when he.
Yo, this Lori Daybell stuff, it's like her. Every time I see and listen to her, her delusional mind just baffles me.
Said, I think I am being their fall guy. And I'm like, the fall guy for what? What is it?
That's
Tell me.
good.
What is it that they're trying to pin on you? What did they do? And he just wouldn't say anything else. And then, so then I get frustrated again because he's not answering my questions. So I turn around and I'm going to walk away again, you know, because I'm just so frustrated that he's not saying anything. And that's when he tells me either I am a man of God or I am not.
All right, we could do a whole hour on Zulema too, what she knew and didn't know, possibly. But we're talking about Alex Cox right now, and that leads us to our next question in our investigation, and that is, who else did Alex
Direct line to Satan.
Cox kill? We know for sure that he killed the kids, or we believe so. That's the implication from investigators. Lori and Chad went down for those murders. Alex Cox, of course, died, so he wasn't ever put on trial, even though he was absolutely there 100%. Still here helping us with our investigation is Lori Vallow Daybell's uncle, Rex Connor. Also joining us, private investigator Lauren Vellucci. Lauren, what's your take on Alex's role in, we know that he was on some level the family hitman, but was he also part of the brain trust?
Yeah, I think he was. I think he was the one that had the balls to do it. I think that Lori kind of called the shots. But when it came to the actual murders, I think he was a fall guy.
Rex, you do a podcast with, as you said, the good brother. What's your take on Alex? You knew him. What was his role in all of this?
Yeah, I was close to Alex till he became a part of Lori's ridiculous religion. And I'm not so sure that Lori wasn't involved in the murders either. There's nothing that has been proven about that. And so I'm not, with this case, I don't count out anything. Did Alex kill Lori's previous husband, Joseph Ryan? That's possible. I respect the work of Joseph's estranged sister, Annie Cushing. She's been pushing for that. I would love it if that was reopened and we could find more information, if some evidence would come out. I don't know what happened to Chad's next door neighbor who died mysteriously around this same time.
Really?
So I don't count out anything once this evil started being perpetrated by these. And I got to take a little exception to you using the term brain trust with these people. There was not a complete brain amongst all of them. You couldn't put a whole one together. These were ignorant criminals perpetrating evil. I don't think there was any brain work involved. Sorry, I had to get that off my chest.
I hear you. Yeah, it's more like the Three Stooges leading an army of nincompoops there that they were on a run, boy. With the whole doomsday nonsense. Here is the Fremont County Sheriff's Office detective who investigated this case, talk about where Alex Cox's phone was. Near a church 3 miles away from the Daybell residence. And this is basically talking about
the neighbors knew to me
the death of Tammy Daybell.
The device that was associated with Alex Cox and Homer J. Maximus, and looking through the data, the night of October 18th, 2019, that device was at the Salem Church at 10:04 that night, or 10:05 p.m.
Sometime just after 10?
Correct.
Do you know how long the device showed as being located in that vicinity?
In correctional time, I believe it was 10:07 p.m. and it showed him there until 10:45 p.m.
And when we're talking about a geofence warrant, do you know what type of data they're looking?
I would call them the couple in orange. I would call them the couple in orange.
Looking at as far as placing a device there?
I believe that is off Wi-Fi and GPS.
So with the geofence, it's located there until 10:45 p.m. of October 18th, correct?
Correct.
Did you learn anything else in relation to that device as far as any later time that night?
That device shuts off or goes dormant and is no longer there. And it is later picked up at 11:53, roughly 7 miles south of the church.
So the implication there is this is when Tammy Daybell died. She dies next to Chad. He's laying there with her. And but Alex is around. He's within a few miles. Lauren, do you think that Alex was involved directly with the murder of Tammy Daybell? Was he the one that gave her whatever it was that turned out to be her demise?
I do, because I don't think that Chad had the guts to do it himself. And I think that also Lori, to me, seems a bit of a control freak. And so I think she wanted it done right, in her opinion. And so I think that she wouldn't have trusted him to just do it unless she had some kind of a role in it. So I do think Alex was there and participated in that murder as well.
Rex, we know that he likely was there for the attempted murder, just wasn't a very good shot of Tammy. Then what about the night that she dies? Because he's got to get into the house. What's your take? Who killed Tammy?
I subscribe to the theory. I don't have any more insight than anyone else. I subscribe to the theory that Chad let Alex in and they killed her. Someone held her down, someone smothered her. I think that's entirely possible.
And then Chad went on with the theatrics after the first responders showed up and acted as though, oh my goodness, my wife she's been having some horrible health problems. What's your take, Lauren? Rex brought up the Ryan death where he had a heart attack. Alex Cox did get him with a stun gun and then would later joke about it because he was a budding comedian in his mind. Do you think that he also killed Lori's third husband?
Listen, Ted, I think where there's smoke, there's fire. So the amount of death that surrounds this woman, and no, it wasn't like dominoes falling, and this analogy that she gave to Keith Morrison. No, death surrounds her because...
What?
What? I didn't know about the high school sweetheart.
OMG. I did not know about. In 92, the high school sweetheart dies. William LaGolia, who is that? He dies. Joseph Ryan, that's I knew about them. Charged. Oh my gosh. I thought she'd only been married 4 times, not 5. That's news to me.
She is
5 husbands.
killing them or having others kill them. So I'm right on the page as that Rex is. I think that is very possible. And when there's smoke, there's fire. And I think with each murder, with each death, they got more brazen and they made more mistakes.
Yeah, they sure did. And everybody thinks they can get away with it. And very few people can. And this crew, as you said, Rex, they were not a brain trust. They were something very different, evil to the core. And Lori is going to have her final day in court in Arizona coming up later this week. Lauren, Rex, thank you for being with us. Appreciate your time on this Monday night. Up next, what about Chad? Does Chad still love Lori? She says she still loves him.
What?
I'm Ted Rollins in for Vinnie Politan tonight. The subject of our investigation, the woman we used to call the Doomsday Cult Mom, until she was convicted of killing 2 of her children. Now she's just a Doomsday Cult killer. I'm, of course, talking about Lori Daybell. Here's the story. Lori Vallow Daybell's marital history is marked by a series of relationships that culminated in a complex web of criminal investigations and trials. The 4th marriage to Charles Vallow, a member of the Church of Jesus Christ of Latter-day Saints, began in 2006. The couple adopted Joshua J.J. Vallow, Charles's grandnephew, and raised him alongside Lori's daughter, Tylee Ryan. However, by 2019, their marriage had deteriorated, and Charles expressed concern about Lori's increasingly erratic behavior and apocalyptic beliefs. He filed for divorce, citing that Lori believed she was one of the chosen ones preparing for the end of times. And on July 11th, 2019, Charles was fatally shot by Lori's brother, Alex Cox, in Chandler, Arizona. Cox claimed self-defense, but prosecutors alleged that Lori conspired with him to murder Charles for financial gain, including a $1 million life insurance policy. Following Charles's death, Lori moved to Idaho and married Chad Daybell, the Doomsday Prophet. Lori and Chad were convicted of the murders of her children and Chad's wife, Tammy. And now, Lori is a convicted killer in Arizona as well, after a jury found her guilty in the death of Charles and guilty for trying to have her niece's ex-husband killed.
I missed the first one, Nelson Yanes. I missed that one.
There's no Chad without Lori. There's no Lori without Chad. Those two, of course, fell, I guess, in love. And part of their love was this just bizarre religious take on who they were. They thought that they had lived many other lives, been married before, in different galaxies. And at the end of times, they would be standing there ushering people in. The 144,000 would be led by Chad and Lori. And Chad was this prolific writer. Of course, he wrote all these books, and he was the one that was able to bring Lori into his world. And one of the things that he wrote about was himself and Lori and their love affair. He changed the names to James and Elena. And it's gross to listen to, but let's do it.
But on the morning of October 26th, James arrived in St. George, still a bit baffled by the message he had received. MG introduced James to her friend Elena, When their hands touched, he felt a shock pass through him and his heart started beating fast. He had glimpses of them walking dusty paths together, and he realized they had been married during the life of Jesus Christ, and they had been very close to him. At this time, their spirits could not be restrained any longer, and a long-awaited makeout session took place in that lobby. This was manifest in the mortal world to James and Elena through the scientific phenomenon known as loin fire. As they talked, James had a burning desire to make love to her, but he wasn't sure she felt the same way. The erotic tension continued throughout the afternoon. James could only think of her. His desire for her was indescribable. Thankfully, she had worn
What is this, a romance novel?
16 layers of clothing to survive the 80-degree weather, so he was not fully aware that she truly had the body of a goddess. Her dimensions were exactly what he had always fantasized about, but that revelation would have to wait a month. They would both attend the same event in mid-November, and it seemed like that day would never arrive. He knew they had been married before, and they had been close friends with the Savior when he lived in Jerusalem. That relationship was now meant to continue in this lifetime. They hungered for each other, and he leaned forward and fulfilled a promise he had made to her a few days earlier. He gently kissed her tender lips, and the same heavenly electricity filled his entire body. The passionate magic they had felt many centuries earlier came surging back powerfully. James moved to the couch, and Elena straddled him effortlessly, as if they had done this thousands of times before. She
What in the hell is this? Oh! Oh!
fit perfectly on him, and they pressed their loins tightly against each other. They were still
Loin?
fully clothed, but the intensity of the intimacy was undeniable.
The loin fire.
AI did it.
It captured Chad. That leads us to our next question in our investigation. Does Chad still, after all of this, still love Lori? Well, we've got a couple of people that can help us answer that question. Lori Vallow Daybell's cousin, Megan Connor, is with us. She is also host of the Midlife Revolution podcast on YouTube. And Nate Eaton, news director, reporter, and storyteller extraordinaire from the EastIdahoNews.com is with us as well. Nate, you had an opportunity to talk to Lori. We've listened to that interview. And let's start by listening to what Lori says about Chad and the fact that she still, I guess, loves him. And we'll get your take.
You told me years ago Chad was the best man you've ever met.
Chad is a very kind person, yes.
Is that still true?
Yes.
So besides his spirituality, what else attracts you to Chad?
He's a wonderful person. Everyone who knows him knows that.
How often are you able to talk with him?
So we aren't really speaking.
By your own choice or just because it's not allowed from like prison to prison?
Yeah, like the way that the mail works here is very difficult. So we're only allowed to get postcards. Like you can't send a letter to the jail itself. And so there's difficulties within that.
But you still love him.
Absolutely, yeah.
And you've said you'll be exonerated and he will too.
Absolutely, we will.
Will that be before he's executed?
Yes, Nate, before he's executed.
So does it bother you though that in Chad's trial he blamed it on you and Alex?
It's so different what goes on behind the scenes in a high profile case. Okay, there's strategies going on, there's defenses going on, there's all these things going on that you wish, like, why can't we just go in and tell our side of the story? The attorneys are like, you can't do that. We have to come up with the defense, and we have to do this, and we have to do this, and like, why don't we just go? Why isn't it? You thought, like, if you've never been in the judicial system, which I hadn't before, you thought they get to tell their side of the story, what they think happened. You get to go in and tell your side of the story of what happened, and then the jury gets to decide. And that's not what happens. That's not what happens at all. And it's so sad and disappointing that that's.
So you think Chad, they had to come up with a defense just to have one in?
Bitch, please. I just want to snatch that ponytail off the top of your head and whip it around and strangle you with it.
Court, you don't think he really believed or blamed all of this on you and Alex?
Absolutely. And I know that for a fact because John Pryor came and told me that prior to trial.
He did. He said, this is going to be our defense.
He said, I'm going to blame you, and Chad doesn't want me to, and he wants you to know that.
Why has Chad been
timing
excommunicated?
is great. So I think that was false too. That was mean. That was mean.
To excommunicate him?
Absolutely.
Are you still a member?
As far as I know.
All right, Nate Eaton, do you think Chad still loves Lori?
I don't know. I would imagine so. It's as she mentioned, it's hard to have a relationship when your state's apart, prison's apart. He doesn't have anybody else other than, his kids who call him every day. There was one moment, Ted, I remember in one hearing, I believe it was just one, maybe two, where they were physically together in the same courtroom. They kept having these court hearings over the past 5 years where they were never together, but it happened once or twice. And I remember them sitting down at the different defense tables, and they put the attorneys between them. And during a break, the attorneys stood up, kind of walked away to use the restroom or whatever. And Chad and Lori looked at each other and smiled and mouthed, "I love you." And that was the first time they were able to see each other in person. They'll never see each other in person again. And while she maintains her devotion to him, even though the only kind things she can say about him, it seems, is he's kind, he's a nice person, I would imagine that he probably feels the same way about her, but not as much, not as devoted as perhaps she is to him.
Megan, do you think that either one of them has regret sitting there alone in a jail cell, that they let this thing get out of control?
Well, there are two thoughts that I have when I heard your initial question of, does Chad still love Lori? And one is, in Nate's interview of Lori that we were just watching, it's very telling that Lori says we're not speaking. She didn't actually answer Nate's question. She revealed, I think, a little more than she wanted to reveal, because if she wanted to talk about the fact that they were not allowed to speak, she would have said that. But instead, what she said is, we're not speaking. When you say that, it means that one of you is angry with the other, and you're not speaking for a reason. And the other thing that comes to mind is watching Chad during his own trial, watching his body language and how he seemed to physically deflate when the verdict was read that he was guilty. And knowing that that was going to likely be the death penalty for him. And I think there was some form of recognition that happened with Chad at that point where he realized that he had gone very, very badly astray, and that Lori had led him to this point. And so in my mind, I think that Chad has had a change of heart. I don't know if that's accurate or not, but that's what I read by his body language. And for Lori to confirm that they're not speaking means that one of them is angry with the other. And I would wager that probably Chad is angry with Lori and not the other way around.
Nate, who was running the show in your opinion? Was it Chad or Lori? Little Alex at the side?
I don't think Alex ever was leading them, Ted, but I do believe that there were moments where it was Lori. There were moments where it was Chad. The prosecution made a big statement that they were both manipulating each other. So when things weren't moving quick enough for Lori, she would text Chad and say, you know what, go spend time with your family. I don't care anymore. Go live your life. Chad would immediately then beg to come back to her. No, it's going to happen. It's going to happen. But then there were moments too where, Chad would manipulate Lori back by saying he was getting these visions. The love story that you just had, read on the air, that was.
Whoa. And Bowen, the neighbor is a distant relative of yours? Holy crap. So you think Chad killed Tylee and Lori killed JJ, Alex killed Charles to help with Tammy and wow. I feel bad for your neighbors.
And, coaxing her ego and saying, oh, she has the body of a goddess, all these compliments. Lori loves to hear nice things about herself. So it's been described that one was a match and one was gasoline, and together they caused this fire, this explosion.
Good analogy.
And I think there were points where they were both leading each other. Lori definitely has the personality of the leader, of being the one in charge, of being the one that pushes things forward versus Chad, who's a little bit more melancholy.
Interesting. Yeah. Let's get a break here. When guests are going to stick around. When we return, what about Lori? Her mental does she sound normal? Nate will tell us. Stay with us.
The first time JJ visited me after he passed away, he put his arm around me and he said to me, "You didn't do anything wrong, Mom."
Two parents face a jury
over the attempted murder of their own daughter. Court TV takes you inside the trial that's torn a family apart.
The attempted honor killing trial. Live coverage weekday mornings, only on Court TV.
Donna Adelson is facing charges of murder, the death of her former son-in-law.
This is terrible. Now that Donna has turned into a defendant, what's next for the Adelson clan?
The matriarch mastermind murder trial. Live coverage this August on Court TV.
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah, okay.
That's why the neighbors took us there.
Gotcha.
I didn't see the shot at her, and then I came back around and I saw that he was on the ground.
I was told by Jesus that I needed to go back and complete things that I had covenanted or promised to do before I was born.
I thought Tylee did it to get back at me.
We're talking to Lori Vallow. At one point, remember, in Idaho, she was deemed unfit to stand trial because of her mental fitness. A judge said we cannot move forward until things change. Then things did change. And she not only stood trial in Idaho, but then again in Arizona and ended up representing herself. So did she make a full circle? Is she completely with it? Well, Nate Eaton talked to her while she was
she's not completely
in Arizona.
with it.
And
not at all.
The way she says things makes you think she's pretty lucid. But sometimes the things she says, you're wondering, including this.
Do you feel bad about anything that's
Multiple
happened?
personality
Do
disorder.
you have any remorse, any apology, anything?
Bad about anything that's a really broad
It
question.
is a broad question. About the past 6 years, any? Do you feel bad about?
Do I have bad feelings about anyone?
Not bad feelings. Do you personally feel bad or feel some remorse for the victims in these cases?
None of the people are victims. So
Are you the victim? Is that what you're
No,
saying?
I'm not saying I'm a victim at all. I'm not saying that at all. I'm an instrument in God's hands.
You don't feel bad. You're saying none of these people are victims.
I feel
Kay
bad,
and Larry
of
aren't
course.
victims. Brandon's not a victim.
No. I'm not saying that people haven't had hard things happen to them in their life. Everyone has hard things happen to them in their life, right? The judicial system plays up the victim thing pretty big, right? We've seen it happen.
What? That leads us to our final question of our investigation here. Does Lori sound normal? Meaning, is she with it or not? Nate Eaton is still with us, along with Megan Connor. Megan, what's your take on her mental fitness at this point?
Well, first of all, there's nothing normal about what Lori says. Let's just put that out there. Secondly, I really, really appreciate Nate asking that question. That is a perfect question to ask someone with narcissistic tendencies, is if they have any remorse or if they take any responsibility for what has happened.
We know who this is, don't we?
Because someone with narcissistic
Megan.
traits cannot answer that question in a straight way, as we saw with Lori. And so I really believe there is nowhere in her mind where she thinks she has done anything wrong. Now, is she normal? Absolutely not. We have to remember that the standard for mental competency by the legal definition in Idaho as well as Arizona just means two things. One, can you participate in your own defense? And two, do you understand the charges that are being brought against you? So obviously at some point in Idaho, she was not able to participate in her own defense. And that was what got her sent to a mental institution for treatment. But now that she understands the charges and she's able to participate in her defense in Arizona, she became her own attorney. And the judge took her through a litany of questions that confirmed that she was not under the influence of drugs or alcohol. She was not under duress of any kind, so she could legally represent herself. So is she normal? No. But meeting the legal standard to be able to participate in your own defense and to understand the charges against you does not mean that you're not delusional. It doesn't mean that you're not narcissistic. It doesn't mean you don't have a personality disorder. It just means those two things and nothing more.
Yeah, I got to be honest. When she represented herself, I thought we were going to go down some crazy roads there in Arizona, and she was much more capable than I thought she was. Nate, what's it like sitting next to her? What was your feeling, the vibe that you get in terms of her mental fitness?
I think you described it well, Ted, in the fact that in talking with her, if you didn't know anything about her and you met her at a grocery store or something, you'd think, this is a friendly woman who, is charming in a way. But then you quickly realize that she's not 100% there, that as Megan said, she's not normal. And the question is, does she act this way on purpose? Does she know what she's doing? Or has this just become so part of her that this is who she is? There clearly were indications in Idaho that she was not fit for trial. She went away for nearly a year and actually enjoyed her time in the institution and liked her time there. She was able to wear normal clothes and have her hair done and wasn't locked up in a cell all day long. The question will be, will she decide to do what she did at sentencing in Idaho? Remember, you played a bit of it there where she, for 20 minutes, did not accept any responsibility for what happened. It was all me, Jesus loves me, Jesus this, Jesus that. I imagine we could see that again happening in Arizona, and I don't know if she ever will take any sort of responsibility for what she has done.
Yeah, and Megan, she said that she's in communication with Tylee and JJ, and Tammy's her friend in Idaho. What are you expecting in Arizona, talking about Charles and Brandon, who we heard her discount to Nate's question? She scoffed at it. He's not a victim, she claims. What are you expecting in Arizona?
Well, this is the thing that infuriates me more than anything else about Lori, is that she is so disrespectful to her own victims, where she tells everybody that she's in communication with them. You didn't do anything wrong, Mom. She refers to Charles as her husband when actually her husband is on death row in Idaho. This is the thing that I think infuriates me and probably most family members and other victims more than anything else, is her disrespect to the people that she's harmed. But I do think she's going to take her opportunity to give another allocution statement because she knows it's her last chance to speak publicly. In Idaho, she is not allowed to have any kind of contact with the press. She's not allowed to give interviews. And so she knows, I think, that this is her last opportunity to get her narrative out there in the world. And I think she's going to take full advantage of it. The thing that I've said across, the last few years of this is that Lori's going to Lori. She's going to do the things she has always done. Nobody should be surprised by that. Are we disappointed? Are we horrified? Are we shocked? Yes, but we're not surprised because this has been her tactic all along. And it's no different than what she's done in the past. So it's unfortunately super harmful to the victims, both living and dead. But it's something we just have to endure for just a few more days. And then she's going to go away forever. And she's not going to be allowed to speak publicly again, as far as I believe.
Yeah, it could be it. The end to what a saga it has been. Nate, Megan, thank you very much for being here. We appreciate your time. Lori Daybell could have had an amazing life surrounded by children and family. She could have been celebrated, could have been a grandparent, watching little ones grow into happy adults. Instead, she chose murder of her own children, so she could hang out with Chad in Hawaii with a grave digger and a bag of money. Why would anyone make that choice? It's tough to tell, but she made it. And we'll hear from her possibly for the last time in Arizona when she is sentenced for the final time. I'm Ted Rollins in for Vinny Powell, and we'll keep digging.
Okay, so we're back over here again. Oh, my Lord. Okay, and of course they have the music going. So let me see. All righty, so they're getting ready. I don't know why that Lord's getting all his stuff out. I guess he wants to entertain himself. I need some gum. I'm upset. I started some new medication and I think it's making me hungry as hell. All I want to do is eat. Wow. Mm. I told somebody all I want to do is take a nap, and they go, yeah, close your eyes and tell them you're reading. I said, no, I got to be moving my mouth too. Alex tried to pew pew her. We got to be careful with our language. Lead shooter, pew pew. Misfired and then poison. Oh, God. That's insane. What are they talking about? Golf? Okay, they're getting ready. This attorney here, he hasn't done anything. Very minimal cross, very minimal interactions. I think he knows he's going to be found guilty, and he's just doing the minimal. But the interesting thing is the guy right here that I'm circling with the glasses. Well, they're both wearing glasses. Next to the lady's head. This is the defendant. This is the father's, Alibaba's paid attorney, and the mother had to take a court-appointed attorney, and the court-appointed attorney is doing a far better job than the hired attorney. Wow. Exactly, right? Well, the one on the phone, the odds are going to be against him because he's done a horrible job. So I wonder what the betting odds are in Vegas. Let's see what it says. See if I can find some odds. You never know. There's some betting people out there. There are no odds. Church mouse. Is that what you're saying, Tinkitude? You saying you're a church mouse? Nah. Well, it does say that the likelihood of acquittal appears very low. Why didn't my fire alarm go off? It's on. So it's likelihood of them getting out. Everyone is saying very low, of course. I did a poll yesterday, and it was 71% that both of them will be found guilty. 29% 9% was the father would be found guilty. No percent that the mother by herself would be found guilty. Church mouse, you ain't, boo. Snort, 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 snort. I don't know. I always giggle when I hear someone snort.
Self-defense instructions.
Okay, here we go.
Assault in the 4th degree with the alleged victim being Isaiah Williams.
You said his name. They're blocking it because she's saying names. You gonna come back on? Thank you.
I said if it's WIPIC 16.04 directly, I do not object if there's no changes to it.
All right, I would indicate I didn't compare the language. It said WIPIC 1604. If you want to go ahead and just compare it really quick to make sure that it. I shouldn't say I didn't compare it, I did, but I want to ensure that I didn't miss something.
Just to be clear, the state did not modify it from the 1604 as it's provided in the WIPIC grammar. Obviously, the only changes would be the selection or non-selection of any bracketed language. We didn't modify anything else that I can see or recall.
No objection, Your Honor. Thank you.
All right. That will be included. Next, I am going to the section of instructions associated with the burglary in the 2nd degree charge. There was exception taken to the instruction currently number 41. The term enter includes the entrance of the person or the insertion of any part of the person's body or any instrument or weapon held in the person's hand and used or intended to threaten or intimidate.
Not right now, no, because they're held in a jail and they're held on the men's and women's side, so I doubt they have any contact whatsoever.
Another person or to detach or remove property. Mr. Larry took exception or objected to that instruction. I'm not going to give instruction 41. It does not apply to this case. Also, the WIPIC notes indicate that the instruction, this instruction would not be used in the usual case as it does not define the entry of the person in the usual sense, and the evidence that's been presented as it relates to the entry is that Mrs. Ali entered through the front door. She did not break in any fashion, and her entire person went inside, as well as her entire person being just on, well, that's in the building at the high school. So I'm not giving 41. There was exception taken to by Mr. Leary as to number 43, which is WIPIC 6005, which is the inference instruction. And I would indicate that I reviewed the Brunson case, which is the primary case that was referenced in the comments and notes on use from the WIPIC. And it indicates that there are three important limitations that the court should consider as it relates to the use of this inference instruction. As it relates to number 2 and 3, I don't find that there's anything in here that would be an unconstitutional shifting of the burden of persuasion. And certainly this is not attempted, so it doesn't apply to those things. So I think really the first factor is what requires the analysis. And it indicates when the intent of the crime more likely than not flows from proof of the illegal entry, the instruction is appropriately given, provided the inference would not be the sole proof of the intent element. In the Brunson case, it's actually a consolidated case with multiple defendants accused of burglary, different types of burglary actually. And in those cases, the defendants, there was evidence that the defendants had actually broken into a building, broken a window, 3-foot hole in a door, that type of situation, and that was circumstantial evidence related to their entry with intent to commit a crime. And the inference was appropriate. And Mr. Leary has argued that this case is different and therefore that the inference should not apply or should not be given so as to not confuse the jury and I think and potentially to shift any sort of burden of persuasion. Although this case is certainly different, it is still appropriate to give this instruction because there is circumstantial evidence as it relates to her entry in the building, how she entered the building, when she entered the building, the notice that she was not allowed to be there based upon the letter or order from the high school and the like. And therefore, I find that it is appropriate to give the instruction related to inference in WIPIC 60.05, and I will include that. We left off looking at instructions 47 and 48. Ms. Zoe, on behalf of the state, had handed forward some new instructions shortly before our lunch break, which changed or added, I think it's really added to the language as it relates to count 5 for Mrs. Ali. Mr. Leary, did you have an opportunity to review those new proposed instructions, which are to replace what currently are identified as 47 and 48?
I did have an opportunity to review.
And do you have any issues with, let's start with 47.
I did not have an exception to 47.
All right. So I will give the new version of 47 on 48. I would indicate that the proposed language now includes applicable to the defendant in number 1, which had been an issue that you had previously raised. Do you have any other issues?
Oh, yeah.
All right, so I will give the 48. On the concluding instruction, which is really where we left off, 49 as well, I have
49 instructions. That's way too many instructions for my comfort. That sucks.
Proposed verdict form and special verdict form based upon the assault in the 4th degree as a lesser crime from assault in the 1st degree. And he properly identified them as verdict form BBB and BBB-1. So I added those to the packet, and I added that information under instruction 49. I also then changed or added to instruction 49 an additional paragraph related to the second lesser crime. Currently,
If they just find them guilty on all the major crimes, the lessers won't mean a thing.
The
It
version-
don't mean a thing if you ain't got that swing.
of 49 references the lesser crime of assault in the 2nd degree. I just copy and pasted that paragraph and changed the verdict form lettering and changed the charge to assault in the 4th degree, and also indicated that that would only be completed if they found Mr. Ali not guilty of the lesser crime of assault in the 2nd degree, or if after full consideration they could not agree. That is when they would consider assault in the 4th degree. So and then I had added a paragraph for both Mr. Ali and Mrs. Ali as it related to the special verdict forms. That language had not,
We're all confused.
anyways, those paragraphs follow the paragraphs related to the instructions if there is a lesser charge. I'm going to start by hearing from you, Ms. Stone.
Ms. Joner, I think I tracked what the court was saying on what I'll call modified 151, with 151, which is that instruction number, I lost the number 49. That all makes sense to me. Plainly, I think I need to see it in print, but what the court outlined makes sense. In terms of organization, I think I'm understanding it consistent with the court's description, and if it is consistent, then I have no issues with that.
And also, I'm going to hear from Mr. Kading and Mr. Larry. It is still a clunky instruction now, but there just is a lot to instruct the jury on as it relates to how they approach the verdict forms. I believe, and of course, you all will get the actual language later today, but I believe that it's consistent with the WIPIC language.
And I do think that instead of trying, as the court has done here, instead of trying to combine it essentially and consolidate some of that language, I do think it makes sense to simply repeat the language for each of those, so that if they start to feel lost, they can just go back to, okay, what do I do now if it's an assault court, and they can just restart that process essentially on its own. So I think that makes sense, even though it makes it lengthy.
All right. Mr. Kading, recognizing that you're not seeing it completely yet, any issue with the way that I described that?
No, Your Honor, it sounded, I too tried to follow, and it sounded very, very much as good as it can be.
Mr. Larry?
No.
Honey, have a fabulous dinner with hubby. Y'all have a great night. We'll see you tomorrow for the Lori Daybell.
Okay. So I'd like to go through the verdict forms to ensure if anyone has any issues related to the verdict forms. Verdict form A as to first I'm only going to go through Mr. Ali's verdict forms, so I won't repeat his name with every verdict form. Verdict form A, Ms. Stone, any issue?
I did not see any.
Mr. Kading?
No, Your Honor.
Special verdict form A1, Ms. Stone?
Just fixing the name.
Oh, and I'm sorry, I have fixed the name on all of the special verdict forms. I did that over lunch as well.
Thank you, Your Honor. No other issues.
Mr. Kading.
No other issues.
Verdict form B, Ms. Stone.
No issue, Your Honor.
Mr. Kading.
No issues, Your Honor.
B1,
Not that the court hasn't already noted.
and that means that I changed the name.
Yes, Your Honor, exactly.
Mr. Kading.
No issues, Your Honor.
All right, so then on BB, Mr. Kading, you had proposed an instruction for BB, which is the lesser crime of assault in the second degree. And it was not quite the WIPIC language. So I did use the WIPIC language in a proposed verdict form BB. You can see how they're differentiated. I have one proposed by Mr. Ali, and then I put one with the WIPIC language. Do you have any objection to the use of the verdict form that's currently identified as BB-WIPIC 180.05?
No, Your Honor, we should use the correct one with the first.
All right. And Ms. Stone?
Correct, that's same, Your Honor. Thank you.
All right. And then we have BB-1, Ms. Stone.
No, Your Honor.
And I have changed the name for Fatima in that one. All right. And I'm sorry, Mr. Kading, any issue with BB-1?
No, Your Honor, thank you.
All right. So I used Mr. Kading's proposed verdict form BBB that he sent over the lunch hour. Did you have any issue with that, Ms. Stone? And that is for the consideration of the lesser crime of assault in the fourth degree.
No, Your Honor, as long as it conforms to the WIPIC as the court has previously identified it for BBB. I believe it does.
I believe that it does as well. All right, and as to BBB-1, any issue, Ms. Stone?
No, Your Honor, and it does have that change already made to Ms. Ali's name.
All right, Mr. Kading?
I think it's right, Your Honor.
All right. Then we have a verdict form C. Any issue with that, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
C1, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
And then verdict form D, Ms. Stone?
No, Your Honor.
And Mr. Kading?
No, Your Honor.
All right. Now I'm going to switch to the proposed verdict forms for Mrs. Ali, starting with verdict form A, Ms. Stone?
No, Your Honor.
Mr. Leary?
No issue.
Special verdict form A1?
No, Your Honor.
Just one moment.
I'm not noting, just to be clear, her name in each of these. I understand the court's changed that.
Yes, I have. Mr. Leary on A1.
No objection, and I will just acknowledge now that the court.
I'm sorry, could you?
I'm sorry. No objection, and I will just note that the court has acknowledged changing Fatima Ali's name to the full name in all the special verdicts, and I will not respond again as to that issue.
All right, thank you. Verdict form B, Ms. Stone.
No, Your Honor, no issue.
Mr. Leary,
No issue.
B1.
No issue, Your Honor.
Mr. Leary,
No issue.
C.
No issue from the state, Your Honor.
Mr.
No
Leary,
issue.
C1.
No issues from the state, Your Honor.
Mr. Leary,
No issue.
and then D, Ms. Stone.
No issue from the state, Your Honor.
Mr. Leary,
No issue.
and then E, Ms. Stone.
No issue from the state, Your Honor.
Mr. Leary.
No issue.
All right. So I do think that there's one last issue that we need to address. I do not like to assert myself in jury instructions or in legal issues. I think that's the lawyer's job, and this may be a non-issue, but it's also my job to instruct the jury correctly at the conclusion of a case. And on the unlawful imprisonment charges as to both Mr. Ali and Ms. Ali.
If this ends early, we can watch that.
They are charged, and then it says that there is a notice of domestic violence, but there are no facts alleged in the information as it relates to the issue of domestic violence. In the other charges where domestic violence is alleged, it has language to the effect, it is further alleged that the defendant, and it has either Mr. Ali or Mrs. Ali, did commit the above crime against FIA, a family or household member, as defined by the statutes. The unlawful imprisonment counts in both informations do not have that language in it. And so I don't know if that is an issue as it relates to the special verdict form for that count. And if it's not, then everything stays the same.
Probably true.
And I can take a recess if the parties want to look at that issue. Yes. I'll go ahead and take a 10-minute recess so the parties can look at that and think about that. Thank you.
All rise, court's in recess.
For how long? How long? I don't see the Anna Walsh. I'll have to look in long crime. I'm looking. Can you send me a link if you want to see it? Because I'm not finding it. Let me begin. Here we go. I'm not finding a link, y'all. Is it Brian Walsh or Brian Walsh? You said I saw Annie Walsh. Okay. Sorry. And their sound is worse than ours. I have it full. Are y'all hearing it? I have 100%, and you can't hear it. Holy crap. Get the microphone on. Is that not it? That's the only feed I can find.
you can then prosecute on any theory. That's not logical. If you just think about it for a moment, Judge, I would defy well-standing law, Moran, Walsh now, Alberto H., handwrite, the cases we cite, and two of the cases that they cite, Moran and Walsh, that make it clear that elements of the crime at issue, the grand jury has to hear sufficient evidence to make out the elements of the crime that is going to be indicted. What does that mean for this case? What it means is that you have to, if you want to prosecute Mr. Walsh on a theory of extreme trust and proof, you have to give the grand jury at least sufficient evidence, meaning the probable cause to arrest him, on what the elements of extreme trust and proof are. And what do those elements include? They include the three now Castile factors, that the grand jury has to hear sufficient evidence of at least one. I would suggest at least one, if not all three of those factors. They heard nothing at all. And the Commonwealth in their memorandum.
I have this screaming, it's clipping.
And why is that? Why is it important to understand what Riley says and what Riley doesn't say? Because if you just think about it for one moment, if a grand jury only heard sufficient evidence of third-pronged malice, an intent to do an act that a reasonable person with the facts known to the defendant at the time would have believed would have resulted in a plain and strong likelihood of death. And let's just say, for this hypothetical, that the grand jury also heard sufficient evidence of premeditation. Is it the Commonwealth's position that the indictment, whether it's issued with the language of 265(1), would allow prosecution of premeditation?
That's theirs, guys. How's the sound on your end? I can't either. You guys, I have this up 110%. I am looking at my soundboard. I am got everything gained and it's killing me. Yeah. Let me see if I can find another feed. Let's see.
And I didn't wind up scare me. Fish did.
That predicts not the other evidence that they heard. It contradicts the inferences.
Okay, where did she get that feed? That's the feed I need. Yeah, this is a no bueno.
We want to get to breaking news we're following for you right now. That is Brian Walsh. He is in.
Not gonna work, y'all.
Federal sentence and the implications of that on their life and where the children lived. It was clear that
before the blow was struck, life
Okay.
insurance policies named in anybody's name, and there were.
Give me a minute. I'm trying to fix it.
she was murdered, and that's supported by a 3-hour break in the searches from 6:35 until 9:35 a.m.
Wow.
There is significant motive evidence that was presented to the grand jury, about $2.7 million in life insurance, about knowledge that Mr. Walsh knew that his wife was having an affair probably as early as December 25th, 2020.
The way she's sitting, if you put glasses on Michael Jackson, does she not look like she could be related to Michael Jackson? Look at that. Are you not his twin sister or something?
2022. And there was his motive evidence with regard to the conundrum of the federal prosecution and its pending sentence. That's all before the jury. As I understand their argument, it is that those searches that are done, and there's 8 of them done before 6:35 in the morning, are prior to. And even though it's reasonable to say that those searches relate to what you do once you have a dead body, that it's not inconsistent with the fact that he may not have yet killed her at the time that he did those searches. Those are the reasonable inferences they're saying that a grand jury could have found. Why isn't that within the bounds given the evidence that was before the grand jury?
First, the Commonwealth says, on the one hand, based on the and of the young child, that he saw his mother. And then they go on to say, but the defendant was coaching him. And then at the grand jury, they go through an enormous amount of effort to dispute whether the child actually saw her. They put on witnesses talking about everything from how well he understands English, the young child, what he does, what he doesn't understand, that he couldn't have created the searches. But they go on to try to dispute that what the child said is not accurate, and it's the result of coaching by the defendant. That's what the Commonwealth presented. We weren't there, but that's what they presented. Let me talk about the insurance. The court used the word motive. It's possible motive evidence, but motive evidence is not premeditation, and motive evidence is not malice. And there is nothing untoward about life insurance policies named in anybody's name. And there were still life insurance policies presented to the grand jury that still had Miss Walsh as the beneficiary. So now we look at that quality of evidence. It may be some evidence of motive, but it is not evidence of premeditation. It is not evidence of malice according to the case law. And there's nothing in these.
But the evidence of malice that they're going to rely on before the grand jury is certainly contained in those searches.
If the searches happened before.
That's their theory.
That is their theory, but
one of their theories anyway.
But their evidence presented to the grand jury doesn't establish that, and it requires the grand jury to speculate and pile inference on inference and say, well, maybe it could have, I don't know what the grand jury was thinking.
All they have to believe is Mr.
Carmen.
Walsh's own statement that she left at 6:30, right? And those searches.
But I think what the court is saying is the grand jury heard sufficient evidence to establish that somehow, that contrary to what the Commonwealth presented to the evidence, the grand jury can still ignore what the Commonwealth presented, and that is they disputed that the child saw his mother at 6:30 in the morning. So you can't just throw, forgive me, but you can't just throw things against the wall and see what sticks, then walk away and say the grand jury heard sufficient evidence. And because that is the probable cause to arresting.
They don't need Thomas Walsh, excuse me. They don't need the minor's statement to establish probable cause. They can go at it alone with Mr. Walsh's statement. She left at 6:30, and the fact that those 6 searches are done before then. Isn't that sufficient? Counsel, we're talking about probable cause.
Judge, but what?
I'm not talking about proof beyond a reasonable doubt.
No, I understand that. I'm talking about probable cause to arrest and reasonable inferences on trustworthy evidence. What did the Commonwealth do in front of the grand jury? They tried to demonstrate that Mr. Walsh lied about Anna Walsh leaving at 6:30. The Commonwealth spent more than a day putting on evidence that she didn't leave at 6:30. She never left. So what he said was a lie. And that's the quality of the evidence that was presented to the grand jury. So if now the government wants to stand up and say, well, we want to have it both ways. We called him a liar in front of the grand jury. And we don't want the grand jury to believe that she left at 6:30, but we're going to rely on that very same evidence to construct this argument that, oh, as they say on, I forget what page it is, I have it, but they say that in a cryptic one sentence, maybe those searches happened before. And that's all they do.
All right, what's the argument? Let's change the.
Okay, we got to get back, but I want to show you something. Yeah, let me show you what I got. I just couldn't help myself. I just couldn't help myself. There we go. There we go. Can't have any sound with it because I'll get in trouble, but then I pulled this up. Yeah, I can't get it out of my head now. Go figure. Okay, they're back.
All right. Ms. Stone?
Yes, Your Honor, I have provided copies of a third amended for Mr. Ali and a sixth amended for Mrs. Ali information that just alleges or provides that information on the unlawful imprisonment consistent with the notice of domestic violence. Notice of domestic violence for count 3, which is consistent with all of the language up top, both on counts 1 and count 2, including the family or household member with the dates associated with that. I provided copies to defense counsel. I've provided bench copies and a notice to file or copies to file with the court as well.
All right, thank you. Mr. Kading, as to arraignment on the third amended information.
Your Honor, if I could just have one more second.
Yes.
Your Honor, I'm going to object to the amendment for the following reason. The state, having previously rested, I believe that the DV designation in this case would constitute an enhancement, not only as a element that they are asking to include in this court, but for future charges. It does have a lasting effect in terms of scoring offenses, and for that reason, I think that it's more than just a formality that this be amended at this point. I believe Mr. Leary has additional information.
Okay. You are such a shitty attorney. You are. You say a few sentences and then you pass it off to the next attorney. By the way, for those of you who don't know, I just posted jazz musician Chuck Magazone, It Feels So Good. Or whatever. And King of the Hill musician has passed away at the age of 84. That's 4.
Mr. Leary?
I would note an objection. State versus Pelkey, 109, Washington 2nd, 484 at 490, identifies a bright line rule A criminal charge may not be amended after the state has rested its case in chief unless the amendment is to a lesser degree of the same charge or a lesser included offense. Anything else violates the defendant's Article 1, Section 22 right to demand the nature and cause of the accusation against him or her. Such a violation necessarily prejudices a substantial constitutional right within the meaning of Criminal Rule 2.1e, which is now Criminal Rule 2.1. Subsequent case law lessened that rule, where there was a situation where an amendment to the crime charge and its essential elements remained the same, but the date of the violation was expanded, and found that the changing of the date did not necessarily implicate the Pelkey rule, and thus the defendant did need to establish prejudice. So here we have a situation where the state is adding an additional element as to count 3, in my case, which is the domestic violence allegation, as they indicate in the proposed amended information that they are further alleging that my client did commit the crime against FIA, a family or household member as defined. So under the Pelkey rule, it is not an amendment to a lesser included offense.
So I should be honored. I'm honored, Carmen, and I don't say that lightly.
We just also note that this is the end of the 3rd week of trial, and the state has had ample opportunity to review the information. The court has identified repeated errors and mistakes in the allegations contained in the information, to the extent that we're currently operating under the 5th amended information, and the state is now seeking to go to the 6th amended information. Once the state has rested, both defendants have rested, and we've essentially completed the jury instructions and ready to proceed to trial, or to closing.
Anything further?
No.
Ms. Stone?
Thank you, Your Honor. As the court looks at the 3rd amended for Mr. Ali, count 3, and the court looks up to both counts 1 and 2, which have been consistent. I would also point out that count 3 clearly identifies unlawful imprisonment, notice of domestic violence allegation -FHM, family household member, after 7/1/2022, all of the associated RCWs. That notice has been consistent throughout, regardless of what information we have been on. That same is true for Miss Zahraa Ali in terms of that language, so it is not a surprise. Counsel has been on notice of that. There is no prejudice to the presentation of their case. So it's not an amendment, as in something is being added. It was already in there. There's clarifying language following underneath of that count. It is not a additional change to what was previously charged already in that information. Notably, in terms of the counts 1 and 2 for both defendants, that language has already been in there with those same references, cross-referenced essentially in the same documents. So that notice has been there. There's no change in terms of adding family household member to the arguments or presentation of the case, as counsel has inquired. When we talk about the Pelkey rule, the concern with the Pelkey rule is that the state then amends an information such that counsel would not have had an opportunity to properly ask questions, cross-examine witnesses, or address that evidentiary issue prior to the close of the state's case. That is not the case here. So I would disagree in terms of the Pelkey rule that it does not apply here. That is different. And when then that turns into counsel having to provide prejudice for surprise or some way to not prepare appropriately for their case, and that is not the case since it is already charged with the explanatory language in counts 1 and 2 and has remained so throughout. It is in fact charged in count 3 for the unlawful imprisonment for both of them, as it has been throughout. The explanatory language and the narrative fell off in a scrivener's error. So that is the state's position.
Ms. Stone? Does the defense have to prove that they are prejudiced if I were to allow the amendment at this point in the trial?
I believe
I don't know, and that's why I'm asking.
I believe that they would if it was either vague in terms of not knowing what was presented, or if it was not on notice at all. If it was either a surprise or it was vague and they were not able to be able to present that. Under Pelkey is if you were adding a charge altogether, such then that counsel couldn't have asked the questions that they wanted to ask on cross-examination. They couldn't have properly prepared to defend their case, etc. That is not what we have here. If I would say that the situation would be very different if it was only in the header and there was no other charge for which that information was relayed, or charged, so to speak. If that narrative language wasn't included anywhere else in that document, we have consistently had the same domestic violence charge tag added in each of counts 1, 2, and 3. We've discussed it as such. We've actually gone through the jury instructions and everyone agreed that that special verdict forms applied to each of those counts because everybody was operating under that same belief that that language was there. And so there is no surprise, there's no change to how counsel would have asked their questions. It applies equally to counts 1 and 2, and it is listed in count 3 itself. The explanatory language underneath was not also provided in the scrivener's error. So I would ask the court to decline the request.
Mr. Lurie.
I would direct the court and the party's attention to State versus Brooks, 195 Washington 2nd, 91 from 2020. Head note 7, 8, and 9. So basically, if the Pelkey rule applies, and then talk about it mean a bright line rule, prejudice is not required. Head note 9 talks about where the Pelkey rule does not apply. The defendant has the burden of demonstrating prejudice under criminal rule 2.1D. And so I would just, so this is at
Fierce like Frida. Thank you so much for joining. No, they are working through the jury instructions. Monday is the magical day for closing arguments. And tomorrow we'll be doing Lori Daybell. And if we can figure out when and where Becky Gill's motion hearing will be, we'll be doing hers as well. Thank you for joining.
95 Washington 2nd at the bottom of 97 through page 98.
Can you address Ms. Stone's argument that this is not consistent with the Pelkey rule and the bright line rule?
Yeah, so.
Amen, Frankie Leroy.
The Pelkey rule states,
Frankie Leroy.
criminal charge may not be amended after the state arrested in its case in chief unless the amendment is to a lesser degree of the same charge or a lesser included offense. So adding the domestic violence allegation designator, it is not a lesser degree of the same offense or a lesser included offense. Anything else is a violation of the defendant's Article 1, Section 22 right. Okay, so and the only exception that I'm aware to the Pelkey rule is something that expands the date or modifies the date. So the amendment sought by the state is not a lesser degree, it's not a lesser included offense, and does not correct the date of the charged allegation. So the addition of the DV designator is not permitted by the Pelkey rule. So we don't even reach the issue of prejudice.
I think that's where the parties disagree because it isn't an amendment. The state has not changed the charge. The charge on unlawful imprisonment with domestic violence, family household member has been charged throughout. The state did not change the charge. It did not up the charge. It did not add an enhancement to the charge. It is the same charge with clarifying language in the narrative, and that same charge is referenced, or that same enhancement, or not enhancement, that same designator is referenced throughout the document otherwise. So council has had notice to it. The Pelkey rule does not apply because it specifically is not amending or changing the charge that has been there since the beginning of this case.
All right. Can you, Mr. Larry, give me the sites to the cases that you referenced? I got State v. Brooks, 195 Washington, second 91, which is 2020. And the first case, which was 109 Washington, second. That's Pelkey. And what's the year of that case?
1987. So 109 Washington, second, 484.
Yes. All right. And Ms. Stone, I recognize the argument that it's distinguishable. In addition to that, is there any case law that you want to cite that I should review? Although I identified that this was a potential issue, I didn't research it.
I have not had time to do that, Your Honor. I was trying to fix the information, so I have not had an opportunity to look at anything other than literally the court came back in after I came in with the information.
Okay, so would you like an opportunity to look at that? All right, so I'm going to take
another break.
I'll take a approximately 10-minute recess. I'm going to look at these cases. As you may identify cases that you believe are important for my consideration, if you're able to either provide a copy of the case or the site to my clerk and of course to opposing counsel, I will look at those as well. Thank you.
All rise, court's in recess.
Why do they not have their crap together? Okay, now we're going back over to this trial.
Say the argument is that
Get your crap together, people.
alternate theories that she was murdered prior to the searches.
Oh, that's Michelle Jackson. That's what I'm nicknaming this judge, Michelle Jackson. She looks like Michael Jackson family.
Probable cause before the jury is stronger, right?
I think so, yes.
All right. Anything else you want to ask me that you want to tell me?
About premeditation?
Yes.
We shouldn't discard the fact that premeditation requires, I understand there's a lot to do about the time element, and I'm not even going to recite all that case law, but it does, the case law also makes clear, and I cited to the model instructions for homicide on premeditation, that it's not just that someone says, okay, I'm going to kill somebody. There has to be cool reflection, there has to be a thought, and then it has to be followed by action. They have no evidence of that. If the evidence is that now they want to construct an alternative argument that, okay, even though we wanted to convince the jury that Mr. Walsh was lying about 6:30, Anna Walsh leaving at 6:30, and even though we want to try to convince the grand jury that he coached his son and his son never saw Anna Walsh, we will nonetheless use that as sufficient evidence to get the indictment based on premeditation. That is not due process. And that's exactly what they did at the grand jury. They disputed the evidence. They did not endorse it when it came to what time she left and if the son ever in fact saw her. And now they want to use it. If they try to use it, they want to use it to say, therefore, the searches happened before the death. And the grand jury is entitled to do that. When in fact, the only evidence they presented to the grand jury was, you can't believe she left at 6:30, and you can't believe that the son saw her.
So the two of you are going in different directions on the significance of the destruction of evidence. That is, the Commonwealth cites to, and I will candidly acknowledge I haven't looked at the different cases that you cited. I certainly will before I make any decision on this case. But the Commonwealth cites to the defense's argument that is sort of that destruction of, under the law, the destruction of evidence is not relevant to the issue of premeditation. And the Commonwealth cites me to, I'm going to butcher the last of this, I'll spell it so I don't butcher it, DAGENAIS, Dene, a 2002 case for the proposition that evidence of destruction of evidence is highly probative on the issue of premeditation.
Well, I think what that, I'm sorry, I don't want to interrupt.
Go ahead. That was the end of it.
Okay. And I too don't want to butcher the case name.
You can call it just D.
We'll call it D. Look, all that case said was, and the Commonwealth uses it in their memo, all it says is there's no blanket rule.
Prohibition against it.
That's right. But then you have to look at all the other cases that talk about that, and all the other cases, Blakey and all the other cases that we saw, say, well, it doesn't have any bearing, destruction of evidence doesn't have any bearing on premeditation if it happened before the blow. That's the phrase used in Blakey, before the blow was struck. That is bedrock case law. That's what they're talking about. So now, getting to your point, Judge, what is the case that they cite and is Nadborny? And I think that Nadborny talks about, consciousness of guilt evidence that may be used, may also be used to demonstrate, let's say, intent. And it goes hand in hand because there's a difference between the analysis of premeditation and intent. But what Nadborny, a case way back in the 70s, says is that on those facts, you could consider the condition of the body found in the trunk of the defendant's car that had been in the trunk for 4 months and showed decomposition, showed that it was specifically wrapped up like a funeral director may do it because his father worked at a funeral director. And they go on to elicit all those facts of how that type of thinking can be impugned to that defendant. You don't have anything like that here in this case. And so the grand jury didn't hear anything of the sort like that. And Blakey says, as well as any number of cases, say that consciousness of guilt should not be used to try to prove malice or premeditation if you can't demonstrate that the so-called consciousness of guilt evidence, and I will say for purposes of this motion, it's probably likely that at trial, those searches would be considered consciousness of guilt if the Commonwealth can demonstrate sufficiently prior to introducing them that they were in fact created by Mr. Walsh and no other person, that they could be considered consciousness of guilt. But that's the limitation. And the case law that they cite and that we cite go on and talk about the errors that are asserted in appellate review where a defendant argues that you used consciousness of guilt to influence the jury on intent and premeditation. And what the analysis shows in many of those cases is, well, where the jury got a complete instruction on consciousness of guilt and premeditation and all the variations of malice, and many times these decisions are made by a substantial miscarriage of justice. But the point is, they're saying in those cases, we think the jury understood that you can't use that evidence other than consciousness of guilt. So in this case, you might have consciousness of guilt evidence, but that is not evidence of premeditation on these facts. You might have consciousness of guilt evidence, but it's not evidence of intent, and it's not evidence that establishes any of the three prongs of malice. And that's what we argue throughout our brief. I think I heard Your Honor refer to affair, the knowledge of the affair. Let me just talk about that for just a moment. And then I have to circle back and not repeat what I said, but I want to talk about inferences and how they apply to the arguments that the Commonwealth makes in their memorandum. First, I know the government wants, and they've said it to the public, but they're just wrong. Mr. Walsh did not know about an affair, period. What AK, and I'll just use the initials that I did in the memo, what AK told the grand jury was that Anna Walsh had talked about telling Mr. Walsh she had a crush on someone. There was no testimony by AK that Anna Walsh discussed with her that Mr. Walsh knew about the affair. It was ongoing.
I don't think that's correct, counsel.
Okay.
Let me tell you what I have in mind from reading. I just need to find the right piece of paper, but I will. AK testified that the defendant told Anna that his mother had told him that Anna was going to leave him for a guy in DC and take the kids, and that he believed that. That was her testimony.
I'm trying to think of that specific, I recall that specific testimony, but I don't think, I thought it said that, well,
59 to 60 of the transcript.
all right, can you pull that up?
Your Honor, do you have a date from that grand jury?
March 8th, 2023.
Thank you.
The defendant told the police in his January 4th
Sorry.
interview that
Wait a minute. We're glitching.
he had access to Anna's iMessenger on his
There we go.
phone and some access to her Instagram. Those are the two ways that Anna communicated with WF for his testimony. Also before the grand jury was that he, the defendant, searched WF's name 6 times.
So with WF for his testimony and also before the grand jury was that could have done it, searched was 6 times on December 25th of 22. There were 20-something, 21, 25 searches on the 25th and searches between the 26th and January 1st on his Instagram account. They don't know where they were to. Also, before them, messages between WF and
When the, if I may inquire, Judge.
I've got to assess the evidence that was before the grand jury in its entirety. And that was the entirety of the evidence that was before them with regard to whether there was an affair going on and whether he knew about it, right?
Well, that's not the entirety. I'm sorry, Judge. I don't.
Well, that's some of it.
That's some of it. It's not the entirety, though, because the entirety also includes the testimony of the other testimony of AK and the other testimony of WF. And that testimony from WF was specific that him and WF and Anna were talking about their affair and that she wanted to tell Mr. Walsh about it, that she would, quote, be devastated if he learned about it. And then there's this conversation about his mother hiring the psychic and that's where that came from. Hiring a psychic that told her, the mother, that Anna Walsh may leave the defendant for someone in DC. And then WF is asked specifically by the government, was there any conversation about Mr. Walsh knowing, I'm going to paraphrase, knowing about the affair? No. Was there any conversation about whether she had told him about the affair? She wanted to tell him about the affair at some point.
That evidence go to the issue of whether or not Anna knew that Brian knew about the affair, not whether Brian knew about the affair.
Well, when the court recites the fact that if we assume for purposes of this motion that Mr. Walsh is the one that reached out and tried to search for WF, how does that show? How does that demonstrate reasonable and trustworthy and reliable facts, articulable facts, that he knew about, quote, an affair, as opposed to the simple truth that was presented to the grand jury that she had a crush on?
Let's put aside the searches on the searches on the December 25th. Put aside the 21 other searches between those dates, and just focus on his admission to the police on the 4th of his access to her Instagram and to her iMessenger and WF's exhibits of the messages between Anna and himself. As I said, there's little doubt based on what's in there. You know what's in there, that there was an affair going on, right?
And you're referencing the messaging between Anna and WF.
Which,
right.
Correct, which the defendant told the police he had access to that during his interview.
He may have,
That was before the grand jury too.
he may have told, he in fact told the police that, yes, he had access to it. He never told the police that he read those text messages. He saw those text messages.
Isn't that a reasonable inference?
Why would it be? Why would it be a reasonable inference that jumps from the fact that someone may in fact be able to access messaging, but there is no, that he has access to it, but then in fact he did? Why is that?
I don't think that was his, I don't think that's his language on 1-4, but that he had access to it. I'll go back and listen to it again, but my memory of it was that they were coming up on his phone.
Okay.
But I'll go back and refresh it. But what did you want to?
Woo!
Notion that there's no evidence supporting the fact that he knew of the affair. Just doesn't seem to me to be a fair assessment of the evidence that was before the grand jury.
And what we're arguing, Judge, that it can only be a fair assessment based on reasonable and articulable facts of trustworthy information. There is no trustworthy information. There's no information at all that Mr. Walsh read Anna Walsh's messaging between herself and WF.
Does somebody have the January 4th interview, page 30, lines 8 to 22? I have it here. I just don't know exactly. Oh, maybe I do.
There you go. It's a male. It's a man thing. It's just a man thing. Just saying. It's a man thing.
Anyway, I'll go back and look at it.
Hi, Justice Jane. We're on a break.
Location where he discusses in his interview on January 4th.
We're on a break, so we're watching the Brian Walsh hearing.
His access. I mean, you may be right. It's access and not that he actually looked at it.
And I'll take a look and see if I'm wrong.
All right.
Could I just go back to pages 60 and 61? And that
No.
So I thought the court had recited in saying that there was testimony that Brian believed.
Anna believed, Brian believed. So
Where
I'm on 60, line 11. Diana was convinced that she went to a psychic, and then due to that, she was convinced that Anna was going to leave Brian for some guy in DC and take the kids, and that she believed Brian believed that.
Well, but maybe I misheard the court. I thought you said that there was direct testimony that Brian had represented or there was a statement attributed to Brian Walsh.
No.
Okay.
He consistently, throughout his interviews, as I know them with the police, averred that he wasn't having an affair, and he didn't believe she was either.
Okay. So turning back to that now, Judge, line 11 at page 60. Anna can believe what she wants to believe. There is no factual basis presented to the grand jury that Brian Walsh did, in fact, believe that. In fact, the evidence presented that she was having an affair. In fact, there's testimony at the grand jury that this psychic investigation was revealed by Brian to Anna Walsh. So how is it then that when people are sharing information and nothing happens at that time, nothing untoward at all happens at that time, that the government can then move on and pile another inference on top of that inference and say, therefore, Brian Walsh believed there was an affair, and therefore Brian Walsh acted on that belief, and therefore there's evidence of premeditation as opposed to motive or whatever. But how can a grand jury be permitted to pile inference on inference when that's what the government is at, if in fact that's what the government intends? That's what occurred. There is no trustworthy, reliable information that Brian Walsh believed or knew about an affair. And when you consider the testimony of WF at the grand jury, and the testimony in conjunction with AK, did she ever say he was jealous?
Counsel, let's circle back to those December 25th, 2022, the 6 searches with regard to William Fasto on that day. So there are 6 searches that are done on a device that's attributed to Mr. Walsh for Mr. Fasto's name on December 25th.
Carmen, he does look better.
Yes.
Oh. Okay, guys, we're back in the other. Now we're back to our main trial.
Let me ask you this. Brooks, where there's a change to the date or something like that. Even in that case, I would argue to the court that that is an essential element of that crime. The date has to be something that you prove and you're preparing for. And in Brooks, it didn't count as that. So here, because the DV designator is not an essential element, it is an allegation, not an enhancement, not a freestanding charge, not a separate charge to that. Pelkey doesn't apply to that designation addition. And because Pelkey doesn't apply, then counsel has to demonstrate prejudice. And there is no prejudice to demonstrate here because it's already charged in counts 1 and 2. Just as it was charged in count 3, but it has that additional language identifying what that notice is in counts 1 and 2. And all of the questions that we have asked, and specifically defense counsel has asked throughout this case, whether the defendants are the parents of the alleged victim in this case. And so that doesn't change. I don't think they can demonstrate that prejudice. I think that would be the appropriate standard without having been able to find anything about a allegation specifically or an enhancement. Any enhancements were referencing like a school zone enhancement or a deadly weapon enhancement or a firearm enhancement, which automatically comes with an additional.
We'll see how all the trials land. Okay. What mods? We're not following the Washy trial. I don't think we have him in our lineup. So the mods and I will look into that, see when it's going to hit. We may be able to watch it if there's no other trial, but we have other trials we've been following for a longer time. So we'll look into it and just kind of see. No promises.
3 years or an additional 5 years or an additional 24 months based on the nature of that enhancement. There is no additional time that automatically adds
when you add that DV designator to this crime. So I think that prejudice hasn't been provided. I think it would have to be demonstrated, and I don't think it can be demonstrated here.
All right, thank you. Mr. Larry, anything further?
To some extent, it's a distinction without a difference. I mean, to say that this isn't an enhancement doesn't require, school zone enhancement or, additional mandatory penalties. I mean, the DV doesn't, correct me if I'm wrong, I don't have the SRA manual in front of me, but is the state saying that if my client is convicted of domestic violence, attempted murder in the second degree, that the unlawful imprisonment count isn't going to add a point to her score? Because that has a direct correlation as to her sentence. It enhances her sentence by a point, which can be quite substantial depending on, if this was a standalone charge. Well, even then, in the future, as Mr. Kading said, there is an additional consequence. There's a reason why the state is attempting to further allege, and that's because of the sentencing consequences here. And therefore, under Pelkey, it's clear it's not an amendment to a lesser degree or a lesser included offense. It doesn't modify the date. There's no authority to suggest that they have the ability to amend post resting, the afternoon before we head into closing argument. Nothing additional.
Guy, this may be a possibility because his trial date is set to begin October 20th. So mods, let's look into that. Not that we will for sure, but let's kind of put our heads on that one.
Mr. Kading?
It's also because Michael Proctor is a part of it.
Just to clarify, Your Honor, regarding the future, as Mr. Leary mentioned, one of the changes that's been made recently is that if you have two domestic violence related events on separate days, neither one of them can ever be removed from your record. So if someone has a prior domestic violence on their record and then they go to trial and they're convicted of the
He won't keep his earbud in. For someone who doesn't understand English, he's either not paying attention or he understands very well.
second, both of those are not being, they can't be removed from the record. You can't do a vacate because you have two different days. So there are potential consequences that are long lasting from a DV allegation that are not necessarily manifest in this particular case in terms of an enhanced penalty now, but it certainly can affect you down the road. It certainly does have consequences. If it had no consequences, there would be no reason to make a further allegation of domestic violence. It would be a moot point and we wouldn't do it. But we do it. We keep track of those things, and it does have consequences beyond this case.
All right, thank you. So first of all, I indicated that, and I don't ever try and insert myself into the trial or raise issues for parties. I recognized this issue when I was preparing at the start of the trial. I recognized this issue when I was preparing before we ever came into court about how I was going to read the information to the jury. And I specifically went over with the parties how I was going to read the information to the jury. And I said it in such a way that I thought it might raise the issue to the parties. Because when I talked about count 1 and count 2, I specifically indicated that I was not going to read the last sentence. And then when I got to count 3, I said I was going to read it as is. And I recognize that the parties are focused on so many things. I also didn't raise it until we were all the way through the jury instructions because I thought one of the lawyers might raise this issue, and I would not have raised it at all if I did not believe that it could have been a constitutional issue, because other issues, frankly, are waived or could be waived if not raised, but constitutional issues can be raised at any time. And the court wants to ensure that it is addressing issues that could be of a constitutional magnitude ultimately. But with that said, I didn't try and research the issue in advance. Again, thinking that the parties might be addressing the issue with the court. This is a situation where the state is seeking to amend both informations as the information to Mr. Ali and the information to Mrs. Ali as to count 3, seeking to add a sentence at the end of count 3, being identical except naming each defendant in each of their cases. It is further alleged that the defendant, Ihsan Ali or Zahraa Ali, did commit the above crime against FIA, a family or household member, as defined by, and then it lists the statutes. As it relates to amending the information, the standard according to the Brooks case is abuse of discretion, and the court looks at whether or not ultimately, and what I should be looking at is whether or not the decision is manifestly unreasonable or based upon untenable grounds, and whether or not it's, of course, most importantly, based on the correct standard. The state is required to allege in the charging document all essential elements of a crime to inform a defendant of the charges against him and to allow for preparation of defense. That's a constitutional right that each defendant has. In this case, the crime charged, under count 3 is unlawful imprisonment. There is not a separate crime of unlawful imprisonment domestic violence. That's not like a separate definition within the RCW. There is a notice of domestic violence that is included in the informations that have been at trial, that being a second amended information for Mr. Ali and a fifth amended information for Mrs. Ali. The rule allows for an information to be amended at any time before verdict or finding if substantial rights of the defendant are not prejudiced. I do not find that this is a situation where Pelkey applies. This is not a case where the state is seeking to amend to a new charge. In the Pelkey case, the state, after everyone had rested, moved to amend to a different crime, from bribery to trading in special influence. And that is not the situation here. And the Brooks case is a case involving sexual assault and misconduct against a youth. And in that case, the amendment was amending the date range. So I don't find that this is the bright line rule indicated by Pelkey, as I don't find that the notice of domestic violence is an essential element of the crime of unlawful imprisonment. And I do not find that the defendants have proven that they have, or that there is evidence that their substantial rights have been prejudiced. And I indicate that because the defendants have been on notice with the specific facts as it relates to the issue of domestic violence from the other counts, including count 1 and count 2. And I know that those may have changed as to the degree or the type, but they have been alleged to be domestic violence charges, even as they may have been amended. And both of those, count 1 and count 2, has the language that it is further alleged that the defendant committed the crime against FIA, a family or household member. So they've been able to fully litigate the issue of domestic violence throughout the course of this trial, have been on notice with the information contained or with the facts alleged in the
I'll be honest, Penny, you haven't missed that much.
information that have gone to trial. Again, second amended information for Mr. Ali and fifth amended information for Mrs. Ali. And therefore, although the evidence is closed and both sides have rested, I am going to allow the amended information
Mine are open.
to proceed forward based upon the reasons I have already articulated. Mr. Kading, as to arraignment on the third amended information for Mr. Ali.
Your Honor, we will acknowledge receipt, waive further formal reading, enter pleas of not guilty.
A probable cause has previously been established. Pleas of not guilty shall be entered as to each of the 4 counts before the court for Mr. Ali. Mr. Leary, as to arraignment on the sixth amended information.
Preserving the objection, the defense would acknowledge receipt, waive further formal reading, ask the court to enter pleas of not guilty to the 6 counts.
Probable cause has previously.
There are some women that are skinny that you can see an Adam's apple on. When I was super skinny, you could see mine. Just saying.
5 counts.
Just saying.
Probable cause has previously been established. A plea of not guilty shall be entered as to each of the 5 counts before the court as to Mrs. Ali. And do you have the originals of the new information? Okay. Having addressed that issue, then there would not be a change to the jury instructions as we have addressed to this point. Almost 3 o'clock. I believe that I should be able to finalize the jury instructions in approximately the next 30 minutes. And then I'm going to have my judicial assistant review them just to make sure that they appear correctly and are correctly numbered. And they will be emailed to you by 4:30 today. I ask that the parties review the instructions and that the parties confer if you see any error, because even after all that, there can be a mistake in the instructions. If you see an error, I ask that the parties confer between themselves so that we can you can address it in an email that everyone's on and everyone has at least been advised of whatever the issue is.
Your Honor, as it relates to Mrs. Ali's, the change that we previously made to the Sixth Amendment to fix it from North Thurston High School to Timberline reverted back to North Thurston High School on count 4. I wish I was making it up, quite plainly. I need to fix count 4 to reflect that it says Timberline High School as it previously was. While the court is doing that, doing the next 30 minutes, or the other option would plainly just to be to find it out. And that would be I would be fine with that. I don't think there's any confusion that we're talking about Timberline High School.
I think because I've already arraigned Mrs. Ali that it cannot simply be lined out. Why don't you?
Just let you know, Carmen, I've got my live to go over to teleport to your mom when we're done. So maybe there'll be a raid party. I hope y'all will go over there.
Have that. Why don't you prepare your new information, but bring it in. I didn't intend to keep the parties here while I'm working on the instructions. I think the parties should be able to attempt to go back to your offices and then the instructions can be emailed. But if you can do that, I definitely want to take up another amended information before Mr. Leary leaves.
Yes, Your Honor. Thank you. What? Yes.
So I will be in recess. My clerk will call me once
Of
that
course.
comes in.
All rise, open recess.
Okay, so we're done with that. Woo! Yahoo! We're done with that. Okay, mods. Uh, okay, y'all are already chatting in that. Wonderful. I'll respond, Yana, in a minute. Let me get cleared out of here. Well, y'all go on over there. Well, I'm going to make sure she's live before we go over there because otherwise, what's going to happen is they won't have anywhere to go. I got to move things around. I struggle. I struggle. Okay, she's live. All right. So what we're going to do is tomorrow, 11 o'clock my time, supposedly, but if it changes, I'll let you know. It's already posted. You can go hit the notification bell and it will let you know when I'm going live. We've got some giveaways to do. So if you just joined our channel and you like the video, put I liked. I'll show you in a minute how we do that. But anyway, we have the Lori Daybell trial tomorrow or sentencing tomorrow that we will be watching. But we also have Becky Hill. And Becky Hill, we don't know when it's going to be live because it's not posted. So we will keep an eye out on Becky Hill and we will monitor Becky Hill. Hi, BK Jr. Welcome. Thanks for liking. Everybody put the I likeys. You got to share. And if you're first time here and you sub today, put I sub. I got some first timers, put I sub. And you will be entered. So let's go ahead and do the I shared. Let me get the music going. All right, you guys, those are the winners for today. We're almost at the end of the month, so y'all need to get your stuff going. It's free. All you have to do is click the buttons and put I liked, I sub, or I shared in the comment. That's all you got to do. It's free. You may get a wonderful mug, a hat, something from my merch. You will get something from my merch. Okay, so tomorrow we will see you guys bright and early at 11 a.m. Congratulations to all the winners. Please come back. I want to say we've got some new people, and I want to thank all you for coming in, but I also want to thank my ones who've been following me for a long time and who've stuck with me. And of course, my mods, Ronnie, you're my queen bee, June, Yana, y'all are amazing. We have opened up for a couple more spots. I'd like to have at least 2 more mods. The mods, you can do something as just help monitor the chat. keep it going, delete inappropriate things. It's so simple. But if you're techie, we need a techie mod. I have one techie mod. I need another techie mod. So we are opening it up. Go to our Discord. It has been plastered, but I will go ahead and show it again. Go to Discord and go in and private message me, and we'll talk about it. We would love to have some new mods. But thank you so much, everybody, for joining. We will see you first thing tomorrow. Well, not first thing, 11 o'clock. We'll see what time Becky Hills is, so just keep an eye out. Remember, click that bell so you know when I go live, especially when we have cases like Becky Hill when no one knows when the court's going live. All right, everybody, y'all have a great day. Thank you so much for joining. Be blessed. Hug your family. Tell them you love them because, tomorrow's not promised. All right. I promise I'll be here. If I'm here, I'll be here tomorrow. Okay. Bye, y'all. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.